Good afternoon, everybody. It's Ladybug here, and we're continuing to watch Dexter Lawson's trial. If you've never heard of the case, I do a nice recap yesterday when we started looking at his trial. But basically, he's at this point of time accused of stealing a plumbing truck and firing some shots at a deputy. Luckily, she survived and she actually testified on day 1. Today we are on day 2 and it is around noon. And as you will see, Dexter is representing himself and it is quite a show. His opening statement was hilarious and the judge even had to do a little talking to him when Dexter wanted to just not do this anymore. But he is continuing, so we're going to continue from where we left off yesterday. I hope everyone's having a great start of their day. And yeah, spend some time with me and this awesome trial. Okay, we're gonna get started. Just give me 1 second.
Order in the court, all rise. Circuit court is not back in session. Everyone, please be seated.
All right, I hope everyone had a productive lunch hour. Are there any issues we need to take up before we bring back in the jury?
No, Your Honor. Well, I will put a little bit on the record, Your Honor. Amy George is my next witness. She was the crime scene analyst for the basic crime scene. She's gone ahead and gone to clerk's table and reviewed the evidence, and so she's going to be testifying. We won't have to move it back and forth. She's gone and looked at them prior to her taking, just to explain that, but otherwise I'm ready to go.
All right. Mr. Lawson, anything we need to discuss before the jury comes back?
No, sir.
All right, let's call in the jury.
All rise for the jury.
All right, afternoon, ladies and gentlemen of the jury. You may be seated. Everyone else may be seated. Welcome back, ladies and gentlemen. I hope you had a productive meal hour, whether that's eating or getting other stuff done or whatever it is that you needed to do. With that, hopefully you're refreshed and ready to proceed for the rest of this afternoon's activities. So with that, State, please call your next witness.
State would call Amy George.
Ms. George, if you would please raise your right hand. Do you swear or affirm the testimony you give in the case now and hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. State, you may proceed.
Thank you, Your Honor. Could you please introduce yourself to the jury?
My name is Amy George. I work at the Florida Department of Law Enforcement in the crime scene section.
Have you had any education and training in that area?
Yes, through FDLE, it's about a year-long program. The first half is academic and training through all the different types of evidence and sections that we do. And the second half is more like an apprenticeship where I would do the processing of the crime scenes and write the reports. And since that time, I've gone through many continuing education.
Okay. About how many hours of training have you had in these various disciplines of forensic?
Over 1,000.
How long have you been doing this job?
24 years.
Okay. And as a crime scene analyst, what do you do?
I identify, preserve, and collect evidence so it can be examined by other sections of the laboratory. And some of the ways that I preserve it is to document it through photographs, sketching, and measuring.
Were you called back on November 16th of 2021 to an area of Gadsden County off Jamison Road?
I was.
And did FDLE take over the investigation at that area?
Yes,
Was Sean Wheeler named the lead investigator?
yes,
And were you named the head crime scene analyst?
yes.
During the course of that investigation, did you take hundreds of photographs?
Yes,
And did you collect lots of items?
I did.
When you get to a crime scene, do you all know what's relevant and what's not?
No, a lot of that has to do with the background information that I obtained from the investigators and why I'm there.
Is it unusual for you guys to collect stuff that you later find out just happened to be a piece of trash?
Yes,
Once again, do you work in conjunction with the investigators and, hey, this turns out to be something that was important, or no, it's just garbage?
yes.
In this case, what was the initial information that you had as you arrived?
That there was an officer-involved shooting, that a suspect had shot a Gadsden County officer, and she was taken to the hospital, and that there was a vehicle involved in this pursuit and a crash, and that had been stolen also. So, and the subject had fled.
Was the Florida Highway Patrol there?
Yes,
And do they specialize in accidents and reconstructions like that?
yes,
Did you kind of divide up the work where you would do most of the crime scene and they would do the crash?
yes.
How did you get there? How did you get to the scene?
I drove in our specialized van that has a lot of equipment in it.
Okay, and did you have a team of helpers?
Yes, there were 2 others that went with me.
Prior to the jury coming back in, did you and I have a chance to go over to the clerk's table and look through a bunch of photographs and pieces of evidence to confirm that they were the things you collected?
Yes,
I'd like to kind of go through that. Did you also prepare some sketches so that you could later explain to a jury or anybody else the nature of your crime scene and where things were found?
yes, I did.
Okay. And, Your Honor, purpose identifications, stage 7, A and B, I believe, 2 phone boards. I'm sorry, should it be, that's wrong. States 8 and 9, I apologize. Amy George sketch.
Heard.
Okay, clerk, could you please hand that to the witness or show it to the witness? It shouldn't be that one, it should be the other 2. There's 3, that one's not, those 2. Okay, thank you. If you could just show those to her. Do you recognize those?
I do.
Okay, and do each of those fairly and accurately depict sketches that you actually made documenting the overall crime scene?
Yes,
I'd introduce states 8 and 9 at this time.
Any objection? Without objection.
Thanks. If you will, while you're over there, we're going to do this a lot, but I'm sorry. States 3 composite. You may want to leave those phone boards over by that easel because that's where they're going to end up. Three composite. And for court and counsel, I added 2 more photographs. So there's actually A through N Nancy or November. Once again, stage 3, are those some photographs of the crash involved in this scene?
yes,
Okay. Do they fairly and accurately depict some scenes on this from this crime scene?
yes,
I'd introduce stage 3 into evidence this time.
Any objection? Without objection.
States 4 composite. What is states 4?
these are photographs that I took at the scene.
And do they fairly and accurately depict some clothes and other items that you recovered at that scene?
Yes,
I'd introduce states 4, composite A through W into evidence at this
Any
time.
objection? Without objection.
States 5. Okay, I'm sorry. I missed R because I can't spell apparently. So there is no R in that. Appreciate it, Madam Clerk.
For 5.
5, that's already been entered. And once again, state 5, accurately depict firearms from scenes that you documented on that scene.
Yes.
As previously, I note, it entered states 5, composite into evidence. Thank you. State 6. Once again, what do we have in state 6?
These are photographs I took of at the scene.
And do these, or some of the bullet holes and trajectory analysis that you did on scene?
Yes.
I do state 6 composite into evidence this time?
Any objection?
For the bullet hole?
Yes, sir.
Yes, sir.
Yes, sir.
All right. Let me see states 6 for ID. All right, I'll see party sidebar for the objection. All right, Mr. Lawson, go ahead. What's the objection to state 6 for ID?
The state I'll be able to prove beyond a reasonable doubt that I had a Glock 45, a couple of Glock 45 with the one who created them bullet holes. So I'm making it known that I'm objecting to that as not being evidence that support the decline.
All right. Okay, thank you. The objection's overruled. States 6 will be admitted. All right, the objection is overruled. State 6 is admitted.
Okay. I'm sorry, I have it.
Mr. Campbell has
I
it.
walked off without it. Okay. Now, I'd like to kind of orient the jury as I best can. You've got a laser pointer in front of you. If we could show the overall one without the list, the one in your right hand. Yeah, can we put that on the stand? I don't know. Can you see that? Is that too far away for you, Ms. George?
It's fine.
Okay. All right. So can you?
And
use your
just so we
laser
can
pointer?
identify, is that
That should be,
states 9?
that should be states 9 overall board.
All right, go ahead.
Okay. So publishing states 9 sketch. Can you kind of get the jury oriented of what we got, what you were sketching here?
Yes, this is on the right side of the board is Jamison Road, and on the center is the Forest Drive, and straight up and down is north. The bottom right-hand side is where the crash occurred, and then all the yellow markers is where evidence was found throughout the scene.
And Your Honor, I'd ask that the jury be allowed to kind of, I know that some of it, they want to stand up or wherever they need to be able to see best, if you would allow the jury to kind of.
Ladies and gentlemen, can you see? Okay.
We've
All
been
right.
trying to
And
work-
if at any point you can't, let me know and we can make sure you're repositioned. Now, you are going to have this back in the jury deliberation room with you.
So, Ms. George, where was the initial cars part of the crime scene?
In front of 1739 Jamison Road.
And once again, you said that there were some yellow markers on that. Was it a relatively large crime scene?
It was.
Okay. And did you find items going and taking a left?
Correct, on Forest Road.
And some of the photos that we just introduced, do those document what we're seeing on the sketch?
Yes.
And furthermore, on states, what's been introduced to states 8, do we have a little bit more of a close-up on that foam board of the immediate area around the cars?
Yes.
Okay. Deputy, if you would go down and put states 8 up, so the jury can see that. And once again, what have you produced with this sketch?
On the right side of the board is Jameson Road. Bottom hand right is where the crash was with the 2 vehicles, the plumbing truck and the Gadsden County. And also there were markers all around. And then the yellow markers up Jameson Road and then to the left on Forest Drive North. And at the top in the center, there's an arrow that says 10 through 17. And that is not pictured on this sketch. That was on the other.
Okay. And that's just because at some point you either had to zoom in to get better detail or you had to have the overall to show where it went off the board. Is that
Yes.
right? Okay. So I'd like to kind of go through the crash scene first of all. This time we publish states composite A. I'm sorry, states composite 3, states 3.
Right. May I publish?
Can you see the TV from where you are?
Yes.
Okay. Once again, Your Honor, I don't know if there's a way to dim or not, but I'm going to be publishing like I have been with this, just a bunch of photographs. All right, what are we looking at here? Starting with 3A.
This is a photograph of the crash, and the top of the photograph is obviously the sky, but that would be towards the north, is straight ahead, and to the left was 1739 Jameson Road.
Okay, that's our first. All right, so this is when you first pulled up. Is your truck kind of back where that was? I'm sorry.
Yes.
You tried it, decided it's going to go on its own there. All right, so this is where you first kind of pulled up and parked your crime scene truck.
Yes.
Okay, and once again, 1739 is that mailbox.
Yes.
Okay. At this point, is the patrol vehicle actually down in this ditch where it's the frames on asphalt?
Yes.
Okay. And there's a little bit more of a close-up of the damage from the McNeil truck to the deputy's vehicle.
Yes.
Okay. Going next seat.
This is a photograph, and on the right side is a little bit of damage from the vehicles, and straight ahead is 1739 Jameson Street.
That the Rodriguez where she had fled to?
Yes.
Okay. That's the house where she fled when it's been shot.
Yes.
Okay. Going, all right, what are we seeing here?
This is the back of the driver's side patrol car, and the base of the car is resting on the asphalt.
Okay. Next.
In the center of the yellow line is a photo marker number 1, and that is a cartridge case.
Okay. What are these? Are these tents something you add on?
That was placed prior to my arrival, the yellow ones, and I have orange ones. I placed the orange ones on top of the yellow ones.
What's the purpose of putting those little markers on things?
To draw our attention to the items, and then also in my sketch, my photographs, and all my evidence, they refer to the same number throughout.
And Deputy, if we could hand the witness states 10. What is states 10?
This is a piece of evidence that it contains several different cartridge cases, and one of them includes this one, photo marker number 1.
All right. What is a cartridge case?
That is what is ejected, or if it's a revolver, left in the firearm after the trigger's pulled. In semi-automatics, it's ejected.
Okay, so this is, as I've zoomed in there, we've got, was it 4
Yes,
cartridge casings?
yes,
And those are the actual ones you collected from this scene.
yes.
I'd introduce States 10 into evidence.
Any objection? Without objection.
Going to our next photo. Okay, now where we backed up a little bit. What are we seeing here?
This shows the driver's side of the plumbing truck and the passenger side of the patrol car. And there's a number 2 that's been placed on the ground. Or, I'm sorry, number 3 that was also a cartridge case. And it was just to the left of the number 3.
Okay. Once again, that's part of what we just entered into evidence. Is that correct?
Yes.
Okay. Once again, a little bit further into the back is showing the damage to the car.
Yes.
Okay. And how many defects did we find into the car consistent with gunfire?
There were 6 holes.
And 1, 2, 3, 4, 5, and then one down here, 6.
Yes.
Based on your training experience, is that consistent with being caused by a projectile, a bullet?
Yes.
What have you done here?
On the bottom right-hand corner is the hood, and that's the hood of the vehicle that I'm standing on. That's the top of our crime scene truck. And this way I can show the south side and the north side of the crash.
And once again, so when we start going to the north side, was there evidence and debris going all the way down this road?
Yes.
All right, what's this showing?
This is a photograph taken from the passenger side of the open door of the patrol car, which shows that the airbags have deployed.
Next.
This is a photograph of the driver's seatbelt in the patrol car, and in the middle of the photograph is it's a defect, is a hole.
Okay. Is that hole consistent in diameter and account with a bullet hole going through the seatbelt?
Yes.
All right. What is this a picture of?
This is the passenger side of the plumbing truck, which has a lot of items in there.
Specifically, did you take note of a pair of sunglasses that the suspect may have been wearing at some point during this case?
Yes.
Okay, and were those sunglasses what I'm zooming in here on the passenger side of
Yes.
the seat? All right. What is this a picture of?
This is the dash of the plumbing truck, and that is a dash camera.
All right. I know this is very dark, but did you go start looking for projectiles? Or well, let me ask. I asked what a cartridge casing is. What's a projectile?
Projectile is the fired portion of the bullet that exits out of the cartridge case.
So once again, you had 6 defects. Did you start looking for the ones that hadn't gone into the victim?
Yes.
Okay. And were you able to recover one of them in between in this scene?
Yes, that is a picture of the once the door panel was removed off of the front passenger door of the patrol car. There was a projectile that was located.
And Deputy, if you could hand the witness states 11 and 12. And what is states 11?
States 11 are several projectiles that were found from the Dodge area, which includes the one in the picture that was from behind the front passenger door panel.
And these are the projectiles you collected from the scene?
Yes.
I entered states 11 into evidence at this time.
Any objection? Without objection.
What is stage 12?
This is a cartridge, which is an unfired bullet and projectile that was near the Gadsden County driver store.
Okay. Did you also, thank you, sir. And I would introduce stage 12 into evidence at this time.
Any objection to states 12 for ID? Without objection.
In addition to documenting the scene and collecting the ballistic evidence at this time, well, let me ask a little bit about, is there a specific firearm section of expertise at the Florida Department of Law Enforcement?
Yes.
And after collection, would that be sent to that department for possible analysis?
Yes.
Okay. Your job is to collect it, and then we decide later what to test.
Yes.
Okay. In addition, were you told about a trail of clothing that was of possible interest in this case?
Yes.
Okay. And is that what we talked about concerning states composite 4?
Yes.
Okay. Now, starting with states composite 4, what are we first looking at here?
This is a mailbox. On this sketch, it would have been in this area on the corner of Jameson and Forest Drive.
Once again, mailbox.
Yes, that just has the addresses on them.
And what do we have here?
This is clothing that has been put in a tree or brush on the side of the road.
And did you mark that as states or FDLE 10?
Yes, I put the marker there to draw attention to it.
All right. And did you end up collecting this?
Yes.
Okay. I'll go on. The next, what are we looking at here?
This is further on Forest Drive to the left or to the west that eventually goes to a corner.
Okay. All right. What are we seeing on this picture?
Can you tell me what number that is?
12. Sorry.
That's a glove on the south side of the road.
All right. And once again, did we collect that?
Yes.
Deputy, if you'll hand her states 17 and 18 for identification. All right. Do you recognize those packages?
I do.
Okay. What do they contain?
Each one contains a glove, one left and one right, the black and red gloves that are in the photographs.
What do you do states 17 and 18 in evidence at this time?
Any objection? Without objection.
And if you could hand states 13. What is states 13, ma'am?
These are a pair of pants that were near Jameson Road.
And once again, are these collected from the crime scene of this trail?
Yes.
Okay. Introduce states 13 to evidence at this time.
Any objection? Without objection.
All right. Now going back to our photographs, 12 was we've already introduced as one of the gloves.
Yes.
11, is that using your laser pointer? Where are we kind of on our trail?
Can you put the other one up?
All right, and that states 9 is
Thank you.
And so the gloves, photo markers 11 and 12, are almost in the center of the sketch, and they're south of Forest Road.
All right, and where's the red and black check shirt?
That's on the north side of the road.
Okay. All right. So were these just off the roadway, like we're seeing them kind of hanging in, either laying in the ditch or hanging on bushes?
Yes.
All right. So if someone running down that road, this would be consistent with them tossing
Yes.
that area. Okay. Going next, our next photo. Did you find this?
Yes. That is a gaiter, or the cloth that some people wear around their neck and pull up over their mouths.
States 19, please. Is that the gator we're seeing in this picture?
Yes.
Introduce states 19 and evidence this
Any
time.
objection? Yes, sir. Without objection.
And where's that on our trail?
It's north of Forest Drive and more on the left side of the sketch.
Now showing you a picture of something else. What is this?
This is a holster that was found.
States 21. Okay. And is that what you collected, that holster?
Yes.
I introduced states 21 into evidence at this time.
Any objection?
Yes, sir.
Without objection.
Where's that found?
That was on the very left side of the sketch after the curve.
All right. Going back to states 10. What are we looking at here?
This was the clothing that was located in the brush off the road, and there are 3 shirts there.
Are they kind of wrapped up in each other?
Yes.
State 16. State 16, please. What is state 16?
This is the shirts that are in photo marker number 10, and it's a camouflage shirt, long sleeve shirt, green and black USMC t-shirt, and red, white, and blue plaid button-down shirt.
Under state 16 is evidence.
Any objection? Without objection.
And is this next photo, you've kind of unraveled them?
Yes.
Once again, kind of showing the layers.
Yes. That's the green shirt, green t-shirt, and the red, white, and blue plaid shirt.
All right, going back to the net gator, is this a closer shot of that?
Yes.
Okay, once again, you documented how you found it. Is this it kind of strung out?
Yes.
Okay, and once again, during COVID, some people use this as a mask for COVID mask and otherwise.
Yes.
And what color is it?
It was blue or aqua.
Once again, this is the holster we've already talked about.
Yes.
All right, what do we got here?
This is some clothing that was closer to Jamison Road. It was in the corner of Jamison and Forest Drive. There's a jacket and some pants and an open chip bag.
Madam Clerk, if I introduce states 13?
States 13.
Okay.
13 has been admitted.
Okay, it has, all right. If we could show 14 and 15. What is states 14?
14 is the tan jacket that is in the photograph.
And what is 15?
These are pocket contents. And there were quite a few.
From that jacket?
Yes.
I entered states 14 and 15 in evidence.
Any objection? Without objection.
Once again, since there was some confusion, I'd enter states 13 if I haven't, if the record shows I didn't. Okay, it's been moved. Okay. I'll make sure I'm right. Lot moving parts. Okay. And once again, on the map, where can you see that on the more detailed, where the jacket, the tan jacket?
That would be on the to the southwest of the intersection.
And these are some of the contents you talked about.
Yes.
And once again, we're back to the start. All right. Did you also, were y'all looking for a firearm?
Yes.
And were you notified that law enforcement had found one?
Yes.
And was it your job to document where you found it?
Yes.
What are we looking at here?
This is a photograph of the vicinity of where it was found. To my back would have been Forest Road, and to my right would have been a residence that was right at the corner of Forest Road, the northwest side of Forest Road in Jameson.
For the record, I'm showing you what's been pre-marked and entered into evidence of states 5, composite A through I. And on the laser pointer again, can you show where it is on your sketch?
It would be this vicinity of where the residence was.
All right. And this is just kind of to orient you. It's where the Watch for Children sign is.
Yes.
Okay. On to the next one. It's kind of turning towards the house.
This was a drive that was behind the house. The house was to the right of or on the sketch, and that drive in the photograph is to the left.
Okay. And then that little driveway, is this to the left side of that little driveway?
Yes, I'm standing in the driveway.
Once again, do you document so that you start wide and kind of scope up on something?
Yes.
Doing next.
And this photograph, the gun is there. It's right next to a stick there. Yes.
This is before you put a label on it.
Yes.
All right. And this a little bit closer.
Yes.
All right. And this actually, you have put 2 of your tents. Why'd you put 2?
The gun was number 17, but also on number 16, to the left of number 16, was a cartridge case.
Okay. When you, let me go ahead, ask states 22 and 23 be shown to the witness. And actually 24 too, I'm sorry, sir. And 25 actually, it's small. Okay, so let's go through them. Going first to states 22, what is that, ma'am?
This is the cartridge case that is pictured at photo marker number 16.
I introduce states 22 into evidence at this time.
Any objection?
Yes, sir.
All right, we'll hold on the objection on that. You want to continue this line and we'll deal with them all at the at sidebar in a moment.
Thank you. All right, what is 23?
This is the Glock pistol that is in photo marker number 17.
And once again, at this time, I'd move it into evidence. I understand the objection.
Under any objection, states 23 for ID.
So,
All right, we'll talk about that at the sidebar in a moment. All right.
All right. Did you, when you first handled that weapon, did you check to see if it was loaded?
Yes, one of my partners did.
Okay. And what was, what was the state of that firearm?
There was nothing in the chamber, and the magazine contained cartridges, unfired ammunition.
Okay. And cartridges are what?
Unfired ammunition,
Okay, how many live rounds were in the clip?
11.
Okay, and is that those cartridges, what's in stage 24?
Yes,
And to try to figure out who the possible carrier of that weapon, did you take some swabs?
I did.
Okay, is that stage 25?
Yes.
And once again, can you tell the jury what it means to swab for possible evidence, genetic evidence?
Now, I take a swab that looks similar to a Q-tip. It's just a little longer and it's sterile. I apply some sterile water to the cotton portion of it, and I rub where I would like to retrieve any kind of skin cells. So in something like this, the gun, I swabbed the grip area that's textured and also the trigger.
And is that what you did, and you packaged it sterilely in stage 25?
Yes.
I would move stage 22, 23, 24, 25 into evidence based on those foundations, Your Honor.
All right.
Get a sidebar.
All right, we'll go sidebar. All right, Mr. Lawson, your objections to states 22 through 25.
Okay, the swab and DNA did not match with me, so therefore it's not supposed to be in evidence because they can't prove beyond a reasonable doubt that I possessed that Glock. So that's my foundation objection.
All right, anything else?
That's it.
Response?
State would argue that, and is going to call for further witnesses, that you can certainly touch things and not leave either fingerprints or DNA. However, the circumstantial evidence of him being on video shooting a gun with that area, fleeing the area, and this being on the trail with the clothing that he was wearing, it at least is circumstantial evidence that this is the firearm. It will also be matched back scientifically to the shell casings found at the shooting scene to that particular weapon. So all of that comes, we believe, is relevant evidence to show that in fact he did possess the firearm and was the person who shot it into the deputy.
All right, the objections overruled. States 22 through 25 are admitted. All right, the objections are overruled. States 22 through 25 are admitted.
Going to the next photo. Is this basically it in the box that we got it in right now?
Yes.
Just the other side of it so you can see the serial number.
Yes.
And is this how the magazine showed when you pulled it out?
Yes.
Nothing for this time, Your Honor.
Cross-examination.
Yes, ma'am. When you ordered the swab test, what were the results?
I don't know. I just turn it in for somebody else to work.
Is there any connection with me and that gun?
Your Honor, it calls for speculation.
Hold on. Ma'am, do you have any direct knowledge about the question?
Not direct knowledge.
All right, the objection sustained. Next question.
That's it.
All right, redirect.
As a crime scene technician or analyst, is your job to collect evidence or potential evidence from a crime scene?
Yes.
Do you then provide that to detectives to try to put that together with other evidence to lead to answers to investigations?
Yes, along with the reports of the people who did the exam of the evidence.
And so, for instance, you said that you went through a lot of study at FDLE. There's a DNA section, right?
Yes.
Okay. And Ms. Hyatt is a DNA expert, all right?
Yes,
There's a firearms section, and Mr. Fondy is an expert in that discipline.
yes,
There's a latent print section, and Ms. Knudsen would be the one to talk about that, correct?
yes,
So while you collect the evidence and take it somewhere, as far as drawing ultimate conclusions on it, that's left to the investigators and ultimately to a jury, correct?
yes,
You testify all the time, but deciding who's guilty and not, even you or the FDLE doesn't decide that. That's a jury's decision, correct?
correct.
I just realized I forgot to, there was one set of evidence that we didn't talk about that I messed up. Sorry about that. Did we do some pictures of the trajectories that I forgot to show you? Did you take pictures of the?
I did.
Okay, and I didn't. So Judge, I'm now showing her state's composite 6. It's been previously moved into evidence.
Yep, state 6 has been admitted. Go ahead.
All right.
And based on the expanded direct, Mr. Lawson, I'll give you the opportunity to cross-examine on this point if you wish. All right, go ahead, counsel.
Thank you. Okay, so what have you done here?
Yeah, I put labels with letters on them, those stickers, next to each one of the holes, labeled them A through F.
Okay, and in this particular shot, we can only see basically the passenger side window, the top being A, and it goes, 4 of them are in the glass, 1 going through the door.
Yes,
Okay, but if we go a little bit further, then we can see, is that the lowest one, F?
yes,
Okay, so once again, how many bullet holes went through that car?
5 or 6 holes.
And now what have you done?
Now I put a trajectory rod, it's a rod, through the hole, and those white spheres are for a 3D scanner that I use. So those aren't used for just the trajectory, but the rod is there to show in what direction the path was.
So that's the way that the bullets were going through that car.
Yes, from the right side of the photograph into the car to the left.
Same thing with that door.
Yes,
And once again, that lines up with the defect in the safety belt from the driver's side. Those bullets did go through and eventually went into the passenger compartment of the driver's side, right?
yes.
Nothing further, Your Honor.
All right, recross as to the new information.
Okay, Amy, if you can't prove premeditated, if you can't prove premeditation, how can you prove that you I possessed the gun and there's no fingerprints on DNA on the gun period of mine? If you can't prove premeditation.
That's outside the my scope.
Okay. So it doesn't say who put the bullets in there. It don't say who put the bullets in there. Fingerprints say who put the bullets in there.
All I do is I collect the evidence from the scene and give it to others to examine.
All right, appreciate it.
Redirect?
No, sir.
All right, Mr. Judge, you may step down.
Subject to recall, but you can go back.
Okay.
Thank you, Your Honor. State call, Mr. Knudsen. She hear you? Okay, well, then I'll go. But Your Honor, I apologize. I need to go ahead and recall Ms. George.
All right,
Just reminded me I forgot to bring in one piece of evidence.
all right. Ms. George, you may return to stand. I remind you, you're still under oath.
Deputy, if you can give her states 28. Okay. All right. I forgot something, didn't I?
Yes.
Big one. Did you, not long ago, request to go to TMH and recover a projectile that was removed from the victim in this case.
Yes, on May 4th of this year.
And is stage 28 the bullet that was surgically removed from Ms. Harms?
Yeah, I received it from the Tallahassee Memorial Healthcare.
I introduced stage 28 into evidence at this time.
Any objection?
I object.
All right, basis.
You said it was a different, you said it was a different, bullet.
It's not a question. This is directed to me. What's your objection?
Said it was a different, bullet, all right?
All right, I'll see the parties at sidebar. All right, go ahead. What's your legal objection?
Yeah, Jason is okay if it was another bullet. Okay. Different from really I need clarification on what you're talking about, because you're saying you putting it into evidence, and I'm trying to figure out what's so different between that bullet and another bullet. Can you explain that?
I'm not explaining anything, sir. I'm ruling on a legal objection. You can once we deal with this evidentiary issue, you're going to be given the opportunity to cross-examine her. But,
Okay.
all right, the objection's overruled. The objection's overruled. States 28 is admitted. Mr. Campbell, you may proceed.
And once again, stage 28, once you collected that from PMH, it too was processed and sent to DLE's lab.
Yes.
Nothing further at this time.
All right, cross-examination.
Was that a different bullet than the ones that were found? Or is that coming from the same gun?
That one was removed from Officer Hearns, and I received that. The other ones that were a different state exhibit number, those were from the scene. Those were from the Gadsden County Sheriff's Office patrol car.
But do that particular bullet that y'all retrieved from the hospital, was that from the same gun?
That would be a question for the firearms examiner.
Any redirect?
Yes, sir.
All right, you may step down, Ms. George, again, subject to recall.
State recall Trooper Paul Azra. You may want to give him this. Pat heard that. No problem. Well, I'm going another direction. He'll be here. I've got plenty of witnesses. I'm good.
And as the witness is approaching, counsel, I just want to housekeeping on states for a composite exhibit. There is no states for Romeo, for uniform, or for Victor.
Okay, so thank you very much. I appreciate you picking that. Thank you. Yeah, that's fine. No comment at all.
All right, if you would please raise your right hand. Do you swear or affirm the testimony you give in the case now and hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. All right, state me. Proceed.
Thank you. Could you introduce yourself to the jury?
I'm Paul Azraq. I'm a state trooper, but I have a rank of corporal, which means I'm a traffic homicide investigator.
How long have you been working for the Florida Highway Patrol?
Since 2012, which would be approximately 10 years.
Can you spell your name for the court reporter? 'Cause she's
Absolutely.
about to glare at me.
My first name is Paul, Paul. Last name is Azrak.
And can you give a little rundown of how you became a traffic homicide investigator?
Absolutely. I was always passionate about traffic crashes, and when it comes to traffic homicide, you have to go through extensive training. I have the 3 core classes, which is basic, advanced, and recon, and I have over 800 hours of training. And I'm actually a part of our Florida Advanced Investigations and Reconstruction team.
How long have you been working in that discipline now?
4 years.
How many crashes have you worked?
Crashes since 2006, when I worked for the Miami-Dade Police Department as a public service aide. So I would say at this point in my life, over 1,000.
And in addition to doing traffic reconstructions, do you have some advanced training concerning information, electronic information that's stored in motor vehicles?
I do. What this is called an event data recorder. It's basically the black box that's inside cars that motor vehicle companies have put into by regulation of the federal government, so we can see what happens in a crash for not only just for our investigative purposes, but for product liability, making sure that there's no faults in the car. And I have extensive training in that, where I have EDR 1 and EDR 2, which is black box 1 and black box 2 training.
Okay. And have you been allowed to testify as an expert both on reconstruction and EIR in the past?
I have not.
Okay. Is part of your duties with the Board of Highway Patrol to go and collect the information from those black boxes and from scenes to be able to give analysis to what happened on that scene?
Yes, and I should have stated that I'm also a technician and been through the class as well. So there's a technician side, someone that can grab the information, and someone who can read it and understand it, and I have both.
Okay. At this time, I would tender the witness.
Any voir dire of the witness for his qualifications? All right, hearing none, state you may proceed.
Okay. Were you charged with working a crash that happened on Jamieson Road back in December 16th, 2022?
I was.
Sorry, November 16th. I apologize.
Yes, November 16th. I was.
Okay, sir. And as an accident crash investigator, do you look at things a little bit different than the normal Joe?
Absolutely. But I would say most of our traffic crash investigators, which are troopers, look at the totality of every crash that we come to based on our training.
Okay. When you got there, had the suspect been arrested? Was everything safe? And was FDLE already there kind of working the scene?
To my knowledge, I believe they had possibly apprehended the suspect. I believe I started collecting evidence around 2:00, and I don't really recall worrying about that so much. I was more focused on my assignment, which was gathering all the evidence from the traffic crash itself.
Okay. So when you first got on the scene as a traffic crash, what's the first thing you're looking at?
When I get on scene, the first thing I do is you have to look at the whole scene. You can't just focus in on one item. And what I found very odd is that the two vehicles were stuck together, and we had a very long scene. And based on the totality of this evidence, you had crush damage that was consistent with a low speed crash. I say high speed because I'm a state trooper, and the interstate is between 70 and 90 miles an hour, some of these cars. And the amount of crush damage that I've seen throughout my life is a lot more extensive than what I saw on this scene. But I had a very long scene, and I still had two vehicles that were up against each other. So I had to walk the scene to see more.
In all the years of working high speed and low speed, have you ever seen two cars stuck on one on top of the other like this?
No, I can only comment one time, and that's a parking lot crash where two vehicles came out at the same time of a parking spot and stuck together. Again, very low speed, and they didn't travel very far.
That was significant to you that we had this much damage and this much scene?
Yes.
What else did you notice?
I noticed fluid trails, and we had gouge marks, which gouge marks are from the metal of two vehicles. When they meet, when cars crash, the noses go down, the frames of these cars make crevices into the roadway, and it helps us to identify where these two vehicles have hit. Also, we have what appeared to be two vehicles stuck together in the front, which would be a front end collision. And vehicles, when they hit, want to rotate, okay? And we didn't have, and we have 100, if I can just go, where AOC was, where the area of collision was to where final rest of these vehicles was 103 feet. And I know that because of the fluid trail that came from the patrol car, which we later would find from a vehicle inspection, but you have a trail like breadcrumbs to show you where they hit and where they ended. And during this entire interaction with these two cars, they didn't separate. They stayed together. And something else to remember here too is a crucial mark are tires. Tires, when you apply your brakes, the wheel locks and the tire doesn't move. It it causes a tire mark, right? A brake mark, because it doesn't want to rotate. In this case, we had an acceleration mark, which is from driver input. When someone mashes the accelerator, it causes the tires to rotate very rapidly. And it was on the right-hand side, and through my reconstruction, you can see that from the truck. It matches the truck if you put these vehicles together, which indicates that this truck, after the collision, pushed that patrol car 103 feet into a ditch.
In trying to look at this and do your analysis, did you provide and prepare a sketch that will help the jury understand each of the things we've talked about?
Absolutely. And what this sketch was collected from it's a 2-scale diagram that I utilized what's called a total station. It's a mapping. It's forensically mapping the scene. Basically, we go out and we mark every bit of that roadway, every bit of the roadway evidence was marked, all the evidence I just described to you, and it's a 2-scale diagram for you to see.
Deputy, if you could show the witness what's been pre-marked, shown defendant as state 7. Trooper, is that the sketch we just talked about?
That is my sketch.
Okay. Does that fairly and accurately depict your analysis in the crime scene in this case?
It does.
I'd introduce state 7 into evidence this time.
Any objection?
Legit.
All right, I'll see the parties at sidebar, and if you'll bring state 7 right up here. Do you want me to? All right, the basis of the objection.
Well, the basis of objection is the witnesses misleading the jury to believe that this wreck was more than what it is. Like he said, 123 feet.
I think the testimony was 103 feet.
103 feet. 103 feet. He said 103 feet. Okay, but the tires is off the ground. So how could it be more how could it be more than a normal wreck when the tires off the ground and the more force behind the wheel and about more force behind the truck?
All right, the court finds that the objection deals with the difference of interpretation of the defendant and the witness, an area that can be properly explored under cross-examination. Therefore, the objection is overruled, and states 7 is admitted. The objection is overruled. States 7 is admitted.
Move to publish at this time, Your Honor.
You may.
Okay. Now, Trooper, Corporal, pardon me.
Oh, you're fine. I'm a trooper.
I don't know if your eyes, mine, are not as good as they once were.
I'll do my best.
Okay. Can you see that well enough from where you're sitting?
Can the jury see this okay?
Okay.
As long as they can see it, I'll figure it out.
All right.
If the witness needs to step down, he can approach it. So
You've actually got a laser pointer right there, too. So we've been using a lot of lingo, and I want you to kind of orient your sketch. What we're looking at here, when you first got things on.
if you can step down.
If you don't mind, I'll help you guys out. So this is a 2-scale diagram that I've used based on collecting the data with being on scene. It goes into a computer program, and it goes to scale because everything that we've measured, it's just like a tape measure, but with computer, with like a total. And what we have here is arrows, right, which show direction, and that's depicting this truck, which I labeled as B1. And then this vehicle that is stopped is the patrol car. And I know it's hard to see V2 here. That's what I've labeled the patrol car. And based on utilizing what's called that event data recorder, which is the black box, what it showed is that the patrol car was at 0 miles per hour prior to this wreck. Okay, but it did show that at 2.5 seconds, that this vehicle was at 11 miles an hour. And then at 0.5 seconds, it was at 21 miles an hour. Well, this vehicle was accelerating, also based on that event data recorder, because we can see percentage of throttle, which is your accelerator pedal. So it was at 99% from this point all the way into impact because there was no brake applied at all. And utilizing the speed and impact formula that we have based on my training experience, okay, we don't do exact speed, we do a range. And the range of impact was between 20 at a minimum and 24 miles an hour. That's why I said it was a low speed crash from it. Now what we have right here is called an acceleration mark. Okay, and that acceleration mark is due to driver input. When you slam, or you should say slide is the bad word. When you press on the accelerator pedal to cause the engine to get maximum acceleration, it causes tires to spin. In this case, only one tire, because some vehicles both can go and others can be one, positive traction type deal. Okay, so once we have this acceleration mark, these are gouges that are here. I believe there were 6. And then once this vehicle was pushed, there's this other gouge mark right here, which shows when that truck came over the top of that patrol car, and that was caused by the frame of this patrol car right here. Okay, we have evidence from that vehicle, that truck here. All this evidence is numerous pieces from the patrol car, plastic. And this plastic was specific to the patrol car. Have you guys, well, I'm not gonna ask you a question, I'm just gonna tell you. No, go ahead.
Let me go ahead. I'd like to break this up first of all, because you had used some terms earlier.
Yes, sir.
Based on the asphalt, are you able to tell where these cars first made impact?
Absolutely. And that's called the gouge marks right here. And I documented them with the total station, there were 6 of them. And that's when I told you, when 2 vehicles collide, they dig down, and it's the frames of the cars that dig into the asphalt itself and show where they both collide.
Okay. And you said that those gouge marks, and I think you said there were 6 of them, based on 20 to 24 miles per hour, if it was a normal accident traffic, would you have expected those 2 cars to stop within 5 or 10 feet?
In head-on collisions, there's generally not a lot of, and generally in head-on collisions, they're a short scene. And in a low-speed head-on collision, it really shouldn't be, it's unorthodox for it to be 103 feet long, but this doesn't happen because of that amount of speed. The car doesn't, the trajectory doesn't go like that. This doesn't work. Cars also tend to rotate.
Okay. And your work is, do you have to rely on physics?
Yes.
And based on basic physics, object, Newtonian physics, if 2 pool balls hit each other at the same velocity, they would stop right there.
Yes.
Okay. Since we're talking about a head-on, was the truck a good bit bigger than the patrol car?
So 8,000 pounds versus 4,000. So approximately double the weight.
Okay.
So because of what he's explaining, or what he's stating, this vehicle basically is bringing all the mass. So 2 full balls weigh the same, or I should say weight, that's bad. They have the same mass. And if you have the same mass, when you hit, you stop. But if one has greater mass than another, it'll move that object. It's Newton's second law. Whatever action there is a reaction.
In football, it's basically a linebacker meeting a wide receiver.
Yes, that's a better one. I'm sorry. That's a better one.
Okay. However, even with that 2 times the mass of the patrol car, if everybody had hit brake or at least stopped, where would you have thought that crash would have stopped?
So there is no indication of braking. When the deputy was, when the patrol car, when this truck hit this vehicle, there is no indication of braking because there is no tire marks, there's no skid marks. There's no indication that either vehicle's brakes were applied after the collision. But what we do have is we have a trail of the collision itself. We have pieces of the car coming off as it's being pushed. And like I said, breadcrumbs with that fluid trail that came from the patrol car as it leads down. This is the fluid trail coming all the way down. And then what this is a furrow mark that was caused by this truck up into the point where the vehicle itself, the chassis, I remember they saw the picture, I think, I didn't really get to see those on the corner. but the frame, because there's a
We can show it in a minute, and if that'll help you.
Yeah, the frame of the car is on the asphalt, which didn't allow the tires to go any further. So there was a great amount of friction pushing back on those trucks, and that's why it went pretty much over that car, and the tires weren't touching the ground any further. And I believe that is why that vehicle could not move any further.
If the truck had not lost its traction, would it have rolled right up over the top and
There's a
crushed it?
possibility it could. It has a higher center of mass, meaning it was higher than that vehicle. And as you've seen the pictures, this car has a lower center of mass, which means it could have gone over the vehicle. It's definitely lighter.
Okay. If we can have your seat.
Absolutely, sorry.
You're doing great. And if you need to, if that's going to help you at any time during your testimony, let me know. Is there anything else while you're still up that you want to show them?
I just want to say one more thing. There was no indication of avoiding this vehicle. There was no swerving. And you would see that by tires. And tires tell a story, just like all this other evidence tells a story. And what this shows to me is that there was no indication of trying to avoid. If you see something in the road, you swerve, you cause a yaw mark, you cause a shift in the weight of the car, which would put down the marks on the road from the tires. And they were not.
Go ahead. You used a term that I hear troopers use a lot, but I've never really understood. A yaw mark. What is a yaw mark?
A yaw mark is when a tire is side slipping. It's rotating, but it's side slipping. So let's say my principal direction is this way, but my tires are faced this way. The tire is rotating, but going in that direction. And have you ever seen it where people turn and they keep going straight and they don't mean to? But usually the car itself is actually starting to rotate, but they're still heading in this direction even though they're rotating. So that's what a yaw mark is.
Thank you.
Absolutely.
Now, you talked about some pictures, and Your Honor, with your permission, I'd like to publish once again states 3.
You may.
Going to. Once again, you were describing, this is some photographs of how the objects at rest. You said that, which photo is it? That one or that one you want to?
This one's good too, because as you can see, the rear of that vehicle is pressed up against all that brush. And it's, if you guys ever see a car wreck, tree always wins. And that's a lot of brush. That's a lot of pushing of the vehicle. But I guess if you keep going, there's also one I thought where it showed there you go. So right there, right where his mouse is, that's the frame of the car. That is the strongest portion of a car. And it's sitting on top of the asphalt. And if you all notice, the tire is no longer making contact with the ground. I know it's hard to see, but if you see the wheel well, how much there's a gap on top of that wheel well, that means that the suspension is hanging. And so it's hanging. And if it wasn't hanging, if it was pushing up against the ground, it would be occupying that space in the wheel well. So it's not free to rotate on anything. It's just hanging there.
And then once again, going to the other side, you said that the truck had actually started to climb up.
Right, it did. And in this point, though, you have the left front that's off the ground and the right rear of that truck. And as I showed you before, this vehicle has a tendency, in order to get grip, it's only on one side of the truck, and it happens to be the right side. So when the vehicle loses traction, it's going, okay, I got a grip. Oh, wait, there's no grip because that vehicle's tire is no longer touching the ground. So when it goes to spin, I'm not a mechanic, but I can tell you that if the vehicle's tire that drives the vehicle is not touching the ground, it's just going to spin in the air. And that left side tire, even though it's part of the drive shaft, it won't move. It would just sit there.
Once again, going to now the passenger side, you still have the car, which again, is that showing right on the frame and in the back?
Right. And I was on scene to tell you that that's what it is. It was on the entire frame of that car was still on the asphalt.
Now going to this, your sketch actually, does it cover too far? This area?
So that's my equipment right there.
Right.
And I mapped, as I know you don't see it here, but I actually mapped even farther back just to make sure everybody saw how wide open this area was. But yes, right from where I started and to where the area of collision is to where they came to rest was 103 feet.
And that we can tell just based on the debris field, the gouge in the asphalt and things like that.
Absolutely.
Okay. Did both the patrol car and the 2500 HD have the black boxes in them?
They did.
And were you able to dump information from those?
I was.
And is that able to give you more information about the driver's input and the performance of each of those vehicles prior to the crash and during the crash?
It can.
Okay. Starting first with the patrol car, did it seem to be, other than being crashed like it is, everything indicated it was operating normally?
There were no error codes through the report. Like I stated earlier, it showed that the vehicle was at a stop and that the driver, whoever was driving the car, had their foot on the brake.
Okay. So the car was acting normal, and right before the crash, it was at 0 miles per hour with the foot on the brake.
That is correct.
Okay. According to the black box of the patrol car. All right. Now we want to flip over to the work truck. Was it operating normally?
It was.
Okay. Once again, did it show how far back in time does that black box show?
May I refer? I believe it was 2.5 seconds, but I don't want to misquote. It's 2.5 seconds.
Okay. So pursuant to the technology, or every time we're driving, is our car keeping up, and can it go back 2.5 seconds to crash?
So with this EDR, every EDR has limitations. And what I mean by limitations is there's newer stuff out there that can do 5 seconds. There's some out there, the early stuff could be even 2 seconds, and it reports all different things. The longer this everything gets better with time, and every manufacturer reports different things. But in this specific EDR, it reports the throttle position, the brake, the acceleration percentage position. The time is 2.5 seconds prior to the wreck, and it will also show you the speed.
All right. So from what you can tell from the truck, both on scene and from the EDR, was it running normally?
Yes.
Okay.
So there were no error codes.
At 2.5 seconds before, what was it doing?
It was it was at a throttle position of 89% at 2.5 seconds, and it was traveling at 11 miles an hour with the brake switch off. Brake switch just means the brake itself, nobody was pushing on the pedal.
Okay. So 89% of, I assume, is 100% full throttle?
So I misspoke. So the accelerator position, meaning the foot on the throttle, was 99%. But at 2.5 seconds, there's delay. You ever get it where you push on the accelerator and it doesn't go? That's the delay, because it takes time for the RPMs to build. So at this point, the driver had pressed on the pedal 100%, no more. Well, excuse me, 99%, which that means foot all the way to the floor based on the data limitations. And the throttle was building at this point. So this is 2.5 seconds, 89%. And it was at 11 miles an hour. And then at 2 seconds, so a half a second later, still 99% full throttle, but now, full pedal position. Now we have 99% full throttle. That means the engine is at its maximum at that point. And we were at 12 miles an hour. And this is increments of half a second. And then it goes to 1.5, and then we're at 16 miles an hour. And then at 1 second, we're at 19. And then at a half second, we're at 21. And then at impact, because we work in ranges, I can't definitively tell you that this would be the speed. It's between 20 and 24. So no more than 24 and no less than 20 would be the impact speed.
But from time 2.5 seconds to the point that he smacked into it, he was giving 99% throttle and the truck was given everything it got.
Yes.
Was there any indication at all that he ever tried to brake?
No.
The driver, I should say, that the driver ever tried to brake.
And based on the physical evidence that I showed you and what the event data recorder shows me, it's conclusive from the scene evidence and from this information we gathered that there was no braking at all in this crash.
Okay. And does the EDR actually stop recording once there's impact?
Unfortunately, it does. And these event data recorders are designed, they work with the airbag control module. That's why they stop, because generally after, when a crash occurs, it's mayhem and there's nothing more to pretty much tell us. In this type of crash, it would have been great if it was on, because it could then tell us, why was this vehicle accelerating? Was there still people pushing on the brake? But generally speaking, in this case, you have a truck that hits a car, and instead of having evidence that it's trying to stop, there's evidence that it's continuing to go.
And once again, if the EDR drops off at the time of impact, the physical evidence still shows no braking at all.
Yes.
And in fact, skidding tires because he's trying to accelerate so far.
Yes, an acceleration mark.
Have you had an opportunity, well, let me ask your ultimate opinion on this. Based on your analysis, did the truck intentionally accelerate into the patrol car?
Yes.
Even after first striking, did the truck intentionally continue to push and power drive it 103 feet down the road?
Yes.
Absent the car going into the ditch and basically the truck losing traction, would that truck have rolled right over the top of that patrol car?
Yes, it's possible that truck could have gone over that patrol car with the amount of weight, and it's still building speed through time and distance that it was gaining. I'm surprised, but as you saw, it was getting there. It was already on top of that car, and sorry.
And based on the design, was there actually a guard on both of these vehicles, a brush guard on the truck and on the patrol car?
Yes, and during the inspection of the car, you can actually see the denting or where they first came together, which was more physical evidence to show it was a head-on crash.
Have you had an opportunity to view a video of this crash?
I have not. I'm kind of excited.
Is it pretty unusual for you after the fact to see if your physical and scientific seems consistent with what actually happened?
This is definitely this has never happened. So I didn't get to do all this reconstruction and not get to see a video.
Your Honor, published was previously marked in your residence, stage 1 at this time.
You may.
Try to get it where it starts for you. Can you see that?
I can. Can the jury see?
Okay.
Look at that. I don't get to usually see that, but what's refreshing is that Newton isn't wrong and that science is still true. And what I do, as you can tell, I've never even seen a video. And that's the God's honest truth, because FDLE would not let me see a video because it was their investigation.
Nothing further this time.
Cross-examination.
Okay. Do you think it matters how far the distance is before the impact?
Do I think it matters how far the distance before the impact? Could you rephrase that?
Okay, the farther I am away, and how fast you going. Do it matter how far I am away before the impact? Because the truck see, it's a 2,500 truck. So this Charger is not, it way smaller than this truck. So if I was farther away and if I accelerated far from the car, do you think it would be a different impact than what it was?
It would have been faster. If you were more far away, if he was farther away, he'd have more distance to accelerate based on the dynamics that I saw today through reading, or excuse me, the day of. Based
on the video, it clearly showed that I wasn't going that fast. I accelerated at the last minute.
You were on the throttle based on the evidence at 2.5 seconds. You were on full throttle, right? And the evidence shows a low speed crash between 20 and 24. But what it doesn't show is that you're continuing to accelerate, and we don't have. There's no physical evidence and any formulas for me to put together to get your speed after. But we do clearly see in the video that you're accelerating, which means you're going faster, even though your vehicle is colliding with that patrol car. What I can also tell you is that patrol car's brakes are not active, because we would have skid marks, which means that the vehicle was pushing that vehicle and still accelerating because there's no resistance in the tires other than the roadway resistance, which is minimal.
So if I accelerated at the last minute, that explains how it ramped up instead of see, if I'm farther away and if I'm going fast, that would have been a way worse crash. That's a bump compared to if I'm doing the mile speed that you said I was doing at 90 miles per hour when I accelerated.
I never said you're doing 90 miles an hour.
What I'm saying, like you saying when I accelerated that I was doing 90 when on the acceleration upon the crash.
So you were accelerating towards a stop marked police car with its lights on, indicating for you to stop. And instead of hitting the brakes and stopping, you accelerated towards a human being inside of a car that you were 2 times its mass.
How could you prove attempted murder though? Like,
I'm not
how
here.
Can you prove,
I'm not here.
How can you prove that it wasn't an attempt to flee? I mean,
all I can tell you, sir, is that if you were operating this vehicle as you say you were, that there's a gas pedal and a brake pedal, and instead of hitting the brake, all I'm testifying today is that you accelerated.
The grill of that truck is metal compared to a Dodge Charger, which is new. The airbag did not deploy in that truck, so therefore I didn't hit that car as it looked, because it would have been way worse. This is a 2,500.
So there's a change in velocity, right? And the patrol car got the greater change because it was stopped. And when this vehicle, the truck, as you're specifying, you had a change in velocity, but not enough to activate your actual airbags. But it did activate because the energy went from one to the other and caused the airbags to deploy in that car, because the accelerometer in that car said, oh my God, big change. Let's protect occupants, deploy airbag, deploy tensioners, keep people safe.
That's the Dodge Charger. The Dodge Charger is a new model car. I mean, so you trying to tell me, right, that how much speed you think I was going upon impact?
20 to 24 miles per hour was your impact speed. It was between 20 and 24 miles an hour.
So I was doing 20 miles per hour. I was doing 20 miles per hour.
Minimum 20, maximum 24.
Okay. So from the distance matters. The farther I am away, and if I'm accelerating, it would have been a way worse crash. I could have passed if I was going as fast as you say I was going. I suppose that went over the police car, right?
Well, I don't really understand your question, but I will say, based on what you did state, which is if you were farther away, you would have more distance to accelerate and become faster, which would in essence be more dangerous. Absolutely. But in this case, the only thing I'm going to tell you to reiterate what you're asking is that you're between 20 and 24 full accelerator, no brake, and you didn't stop, or I shouldn't say you, the vehicle didn't stop until it couldn't go any further because the vehicle was off of its wheels, mounted on the ground, or excuse me, on the asphalt on its frame. And that's why your vehicle even went even higher over it.
If that truck wouldn't have went up like that, would have been a possibility that I would have had an opening with that truck to go around the car? If it wouldn't have went over the car, the truck, could I possibly slid past the truck? I mean, slid past the car.
Are you saying once you hit?
Once the ramming took place, instead of it going like the car is like a ramp. Okay. So like when the truck hit, it went up a ramp like. Well, instead of it going up a ramp, like, was it a possibility if it wouldn't have did that, I would have been able to go around the car?
No, that's not how that works.
That's not how. Tell me how it works.
It works the way you just saw it. Your vehicle went over, and pushed the vehicle into the ditch.
That's a bump. Like that's a 2500. That's a bump. I got a chrome grill on it. So therefore,
are you stating that a patrol car with its lights on, telling you to stop is a bump in your road?
You misunderstanding what my point is. My point is.
Hold on. We're talking over each other. The trooper will want to make sure, let him finish his question.
I'm sorry. You're right. I'm sorry.
Mr. Lawson's going to ask a question, and you're going to let him finish.
Yes, sir.
And then he's going to let you answer the question. All right, Mr. Lawson, go ahead and ask your question.
Okay, I'm asking you, right? Okay, that impact is in the evidence. Like how that is that impact based on when that wheel came up. Is the force still behind the truck?
Where?
The truck is off the ground. Both of the tires is off the ground.
Are you talking about
you got two tires off the ground? Okay, when the truck is sitting on the hood, right? What more force behind the truck after it went off the ground? Is it still force behind the truck after it went off the ground?
Are you talking about the end of the crash when it's
I'm talking about when the car is like going back. The car, you saying I pushed the car by 103 feet. So
right there.
Okay, what I'm saying, the car went like this.
What did it do?
It went like this.
You're saying it's sliding?
It's rolling back. You see it on the video. Can you please play the video again?
Yeah, sure, Mr. Campbell, if you can go ahead and play the video.
Absolutely. So that's the override. And then you're saying at that point, okay, so you know what that is, sir? This officer, or as well as anybody who's ever involved in a motor vehicle wreck and gets hit by airbags, they are usually disoriented. They're not applying the brake. That's why there's no brake marks, because this officer did not apply brakes because they were hit by airbags. And we have a tire that's generally not held by people after they've been hit by airbags. So at this point in time, when you're seeing that rotation, that's the actual steering wheel going about itself on its own. That had nothing to do with your car. That had everything to do with no driver input on her car.
I understand that.
Okay.
That's point taken. But what I'm saying, how you gonna prove it could have been either or? It could have been attempting to flee or attempting to murder. It's how you looking at it.
I'm not doing anything other than
Speculate.
No. I'm reconstructing the crash based on the physical evidence I have and the EDRs, which are the black boxes in this case. I have never stated once here today about attempted murder or anything that you just alleged. I'm just showing you based on my reconstruction and the evidence at hand of the totality of circumstances of what happened today. I never stated that you were attempted murder.
But do you believe that the distance matters upon acceleration? If I'm going 90 miles per hour here, it's the difference between me going 90 miles per hour there.
I'm not stating you're doing now at 90 miles an hour, but distance always matters. Like I stated, if you were farther away from the vehicle, you would have gotten faster, right? If you have full, I agree. I'm not stating you're wrong, but I didn't state you were doing 90. I said at impact, you were between 20 and 24 miles an hour.
Is there a possibility, any type of possibility, that she could have died in that wreck?
Absolutely. A change in velocity, a 20-mile-an-hour impact has killed many people.
Attention is a plan, and the attention is in the evidence itself. I'm not saying if I would have been doing a little faster or been
No.
a little farther away.
That speed range can cause an aorta to rip. Okay. And what happens in interstate crashes, you have vehicles that are traveling at, say, the posted speed limit, and they go to decelerate, and the vehicle can only pretty much decelerate between 15 miles an hour a second. That's generally a range, just to give you guys some understanding. And a vehicle, when they collide, is between, it can range, of course, but a 20-mile-an-hour impact can kill someone, yes.
But is there a possibility that it could have been an attempt to flee also?
I don't know what you were thinking. If you were
I wasn't
attempting to
thinking.
flee, it's on you to tell me that you were. I'm not a mind reader. I'm here to reconstruct your traffic crash and tell you the facts of this
I was
case.
talking about the evidence upon hand. I'm talking about you got a truck that's off the ground, go a chrome grill.
If you
It's
think
just
it's fleeing, I'm sorry.
All right, let's ask a question. Not going to argue with him though. I mean, ask him a question. But if you're asking him ultimately to what got into your head, that's an issue for the jury of whether the state's met its burden to prove the elements of the crime. But go ahead and ask your question.
That's it.
Redirect.
Yes. How much did that truck weigh?
I can get you an exact figure here. £8,280.
What did the driver of that truck tell it to do 2.5 seconds before?
Accelerate.
What did it tell it 1.5 seconds to do?
Accelerate.
All the way up until impact, what was the input?
Accelerate.
And at 20 to 24 miles an hour on a head-in collision, is that capable of ending a human's life?
Yes.
Nothing further.
All right, subject to recall.
Yes, sir. Subject
All right,
to-
you may step down. Trooper Ezra, you're subject to recall. All right, ladies and gentlemen, I think this is a good time for our first afternoon break. So if you'll just leave those notepads face down, we'll take a 10-minute recess.
All right, Special Jury.
Sorry,
That's okay. Do you want to begin next or I it next?
I was going to do,
All right, the jury is departed the courtroom. We'll be in recess for 10 minutes.
like this.
Hey everyone, sorry about that. Hope it didn't finish. We're gonna continue. So it's about 2 o'clock. We're gonna continue that. And mentor lawyer are back here working very hard, so I got a little sidetracked. You have awesome videos coming out. There's mentor lawyer. He's working on Adelson jury selection, so that's going to come out soon. I know everyone's excited about that one. And then there's an awesome analysis coming out Friday. Not sure about the time, so make sure your notifications are on. That's going to all be on Deep Dive True Crime. So let's continue. I'm going to get us set up. So this is your perfect opportunity to go get some food, have some lunch, a late lunch, and use the restroom and whatnot. Okay. Here we go. Okey-dokey. It's about 2:45 for this trial. And let us get going. And please let us know your thoughts in chat or comments about this case. You don't see every day where the defendant is defending themselves, so. Okay. Let's get on to it.
Everyone, please be seated. All right, before we bring the jury in, I just wanted to ask Mr. Campbell what the game plan is for the rest of the day.
Your Honor, I'm an optimist. I believe I'll be able to rest today, sir. I've got 3 FDLE experts and the lead detective left. The expertise should be it's mainly negative evidence, so it's I don't particularly think it's going to be much longer.
Okay.
Thank
All
you.
right. Well, we'll see how far we get.
Thank you, sir.
With that, let's bring in the jury.
Yeah, there's your mic. Yeah.
All rise for the jury.
All right, ladies and gentlemen of the jury, you may be seated. Everyone else may be seated. All right, State, you may call your next witness.
State, we call Karen Knutson.
If you would please raise your right hand. Do you swear or affirm the testimony you give in the case now and hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, you can put your hand up. Please be seated. State, you may proceed.
Good afternoon. Could you introduce yourself to the jury?
My name is Karen Knudson, spelled Knudson, and I work at the Florida Department of Law Enforcement in the crime laboratory as a crime laboratory analyst.
What is the job of a crime laboratory analyst?
In the Friction Ridge section, as an analyst, I examine the evidence for detection and development of latent prints. If prints are found, I will compare them out to known prints, report out on my results, and testify in court if requested.
Okay. You ran out of breath there.
I did, I'm sorry. Too much in one breath.
Don't try to act like me. Just relax. Okay. So what is Friction Ridge? What does that mean?
Okay, friction ridges are found on the palms of the hands, your fingers, and the soles of your feet. They are raised portions. They look kind of like a washboard, and along those raised portions are hundreds of pores. The pores constantly exude sweat, amino acids, salts, and other constituents, and they can also pick up oils from your head, your face, so that when an object is touched, a print may or may not be left behind, and those prints usually require a physical or chemical means to make them visible.
Is Friction Ridge is more commonly known as fingerprinting?
I guess you could say that, yes.
Okay.
Fingerprints are visible, latent prints are not, so.
Okay. And what kind of a training and experience do you have to be working in this area?
I have completed the forensic technologist training program, both in latents and photography. And I also completed the crime laboratory analyst training program, which is 1.5 years long and consisted of a couple of phases. The first phase is hundreds of readings, comprehension tests, comparison tests, oral assessments, all based on subjects within latent prints such as biology and history and detection and development and comparison. And then the second phase is supervised casework, where all my work is reviewed by a senior crime laboratory analyst.
Why are friction ridges useful in criminal science?
Because they are unique to the individual. So if you identify someone you can't say to the exclusion of all others, but it's very unlikely that two people have the same prints.
In the area of friction ribs, have any two people ever been found to have the exact same fingerprint?
No, they have not.
Okay. And have you had the opportunity to work at friction rib at FDLE on casework over the last few years?
Yes, I have.
How many cases have you worked?
Hundreds of cases, I believe. I've been in the section for 13 years as a forensic technologist, and then an additional 6 as a crime laboratory analyst.
And have you had the opportunity to testify, give opinion testimony concerning this area of science?
Yes, I have.
About how many times?
4 times as an expert.
And I would tender the witness at this time.
Do you have any voir dire as to the witness's qualifications? All right, hearing none. You may proceed, counsel.
Ms. Knudsen, did you have an opportunity to be given a piece of evidence in this case?
A few pieces, yes.
And specifically, was one of those a Glock 45 9mm pistol?
May I refer to my notes, Your Honor?
You meant?
You may.
Yes, a Glock 45 handgun.
Okay. Bailiff, if you can please hand that to her. And this, for the record, Your Honor, showing a witness that's been pre-marked entered evidence of stage 23.
Yes, this is the evidence.
Okay. What's inside that box?
Well, there should be a Glock 45 in here, but it's sealed, so I cannot verify that visually.
When last you opened it, did you actually seal and tape it closed?
Yes, I did, and I initialed my seal. So.
Okay. And so when you opened it, there was a black pistol in there?
Yes.
Okay. Now, are you often asked to do fingerprints of pistols, guns, lots of items that you know have been handled by man?
Yes, I am.
Okay. Is there always going to be a latent, well, let me ask this. Is there a difference between a print and a print of value?
Yes, there is.
Can you explain those differences to the jury?
Okay, a latent print of value is a print that has sufficient information along with the quality and quantity of characteristics in order to make a comparison. And by that information, I'm talking about the ridge flow, the pattern type, the ridge edges, the pores, along with the ending ridges, dots, and bifurcations where a ridge will split or fork.
Are there lots of factors concerning how likely a print of value will be left on an item?
Yes, there are factors.
Okay. What kind of factors?
There is a touch factor, and that's how the item was handled, how it was gripped. If it's gripped very tightly, prints can be smeared off. If you put items in and out of a pocket, you could wipe them off. Specifically for guns, if they are safety checked, which they are safety checked multiple times before it gets to the friction ridge section, that very process can wipe prints off. There's a surface factor, and is the surface conducive for receiving a print? So like a clean piece of glass would definitely receive a print better than a brick. So there are different types of items that way. There's an environmental factor, and was it left outside? If it's in the heat, those prints could dry out. If it's in the rain, they could wash off. And then the last one is the human factor. And that's, people could have diseases or be on a medication that causes them to not perspire. So they won't leave a print behind, or they could perspire too much, or there could have been a barrier between their friction ridges and the item that was touched, such as gloves.
Now, you brought up gloves. In the lab, do you often have to handle pieces of evidence.
Yes, always.
Okay. And is it important you don't leave your fingerprints on anything?
Very important, yes.
And how do you make sure that doesn't happen?
I wear gloves.
Now, going to what's been pre-marked shown to you states, the pistol in this case states 23. Did you find any prints of value?
On 23?
Block 45, states 23.
Oh, okay. You're
FDLE 22.
Thank you. I found a ridge detail, but it was no value.
Okay, so some ridges it touched, but not enough to be able to match it to somebody.
Exactly.
So because you found ridge detail, you would agree with me, somebody touched that gun at some point in time.
Somebody did, yes.
And Your Honor, what's been pre-marked and introduced into evidence states 17 and 18 I have in front of me. I'm going to go ahead and open it this time.
Okay.
If I'm wearing this glove and I touch something, am I going to leave any friction ridge detail that you're able to detect?
No, you won't.
Because it's going to be just like the gloves you're wearing in the lab, right? But you got it.
We
Different gloves.
have different gloves, but no, you will not leave any friction ridge detail behind.
Nothing further, Your Honor.
Cross-examination?
Yes, ma'am. Okay. If it's your gun and you know you touched your gun because it's your gun, right?
Okay.
All right. If you put on blood after that, would the print still show up?
Sometimes they will and sometimes they won't. It always depends on how that gun was handled.
So evidence of value is considered as proof, right?
As proof?
Evidence of value. You said you got evidence of no value, right? But if it was evidence of value, it'll be considered as proof, right?
Only if the print of value was compared out and identified to someone.
So if it was no value to who they trying to say had that gun, then there's no proof.
Well, I did not compare the printout, so it's not no value to a person. The print itself is no value, so it could not be compared at all.
Okay, thanks.
Redirection?
Sure. The friction ridge on that pistol could have been mine,
Yes,
could have been his,
yes,
could be the judge,
yes,
could be the defendant.
yes,
Have no idea because it's not of sufficient value, right?
exactly.
Thank you. Nothing further.
Thanks.
All right, you may step down.
Statement call FDLE Special Agent Wheeler. Gosh, thank you.
Please raise your right hand. Do you swear or affirm the testimony you give in the case now and hearing should be the truth, the whole truth, and nothing but the truth? I do. All right, you may be seated. State may proceed.
Thank you. Could you introduce yourself to the jury?
Special Agent Sean Wheeler with the Florida Department of Law Enforcement.
How long have you been in law enforcement?
I've been in law enforcement since 2007,
Where'd you first start?
Wakulla County Sheriff's Office.
And how long were you there?
I was there approximately 6.5 years.
And where'd you go next?
The Florida Department of Law Enforcement.
Have you always worked in that same capacity?
At Florida Department of Law Enforcement,
Right.
I started with the Sheriff's Office as patrol, went into investigations. When I came to FDLE, I started in the major case. Oh, sorry. I talk fast. I started in the organized crime unit where we specialized in narcotics investigations, and I have since transferred to the major crimes unit where we specialize in officer-involved shootings and homicide investigations.
Were you working in the violent crimes unit for FDLE back in November 16th of 2021?
I was.
And were you assigned the involvement of the shooting of Gadsden County Deputy Shakara Hearns on Jameson Road?
I was.
Did you immediately go to that scene?
I did.
Was there a lot of law enforcement there?
There was.
Okay. As the lead detective, are you capable of doing everything yourself?
Absolutely not.
Okay. Are you basically the center of the wheel giving out assignments to everyone?
Yes,
Okay. So do you know Amy George?
I do.
Okay. And is she vastly more skilled at evidence collection and preservation than you?
Yes,
Okay. So did you ask Ms. George and her people to take the documentation of the evidence?
correct.
Were there some other detectives there?
Yes,
Did you assign them various people to interview, take statements from eyewitnesses elsewhere?
yes,
And as these people, the evidence come back and filter to you.
correct.
I want to talk about some of the evidence that was collected. In today's world, are we getting more and more surveillance video?
Yes,
Okay. Is that really good stuff when we find it?
usually,
Okay. Is it sometimes unreliable where we find it?
correct.
Okay. You said that one of your jobs is working officer involved shootings. Do all agencies carry or wear body cam on their person?
They do not.
Is there a vast array of differences depending on which agency, on what kind of cameras, if they have them at all?
Correct. I mean, currently I'm assigned to a 7-county region, and every county is different. It's all based off their policy and procedure, which is established by their agency head.
Okay. So like the Tallahassee Police Department, do they have body cams on every officer?
Most of their officers have body cams now. Yes,
Gadsden County Sheriff's Office, they don't have it.
they do not.
Florida Highway Patrol, do their patrol cars have them?
Yes,
But do they carry body cams?
no, sir.
Did you, in this case, know that you were dealing with multiple agencies? Do you even know what all agencies? you work
On
with?
scene when I arrived, we had FHP, FWC, Gadsden County Sheriff's Office, Havana PD, Quincy PD, Chattahoochee PD, Florida Fish and Wildlife, representatives from the FDLE were on scene. We were also joined by representatives from Leon County Sheriff's Office. So there was a wide gamut of law enforcement officers that responded to assist.
Did you have a chance to liaise with each of them to try to find out, who had found what, and who had relevant evidence?
I did. So upon my arrival on scene, via the Gadsden County Sheriff's Office chain of command, it was requested down from the sheriff that Florida Department of Law Enforcement take lead of the investigation. With that being said, I was the senior agent on scene and the first FDLE agent on scene, so I assumed that lead and role responsibility, and I immediately started taking command and control of the scene and delegating different agents that also arrived in different capacities of things that needed to get done. Because of seeing that size with that many people and that many moving parts, ultimately you want to get as much information on the front end first as quickly as possible. That way you don't lose anything of evidentiary value, or somebody that has some type of knowledge doesn't leave without you getting a chance to interview them. So you sit back and you kind of delegate the moving pieces in hopes to build that picture.
Now, in this case, by the time you on scene, had Deputy Hearns already been transported to TMA?
Yes,
And was she actually headed to surgery by the time you were working there?
yes.
Okay. So as such, at that point, did you know whether she was going to even live or die?
I did not.
Okay. And being in surgery, could we talk to her?
No, sir.
Did you look and inquire whether that her camera or her person might have had video that would have documented this whole
Yes, we did.
thing? And did it?
No, sir.
Pretty quickly, did we start getting contact from the McNeil people, McNeil Plumbing?
Yes,
And did they have something pretty invaluable to us?
absolutely. They
What was that?
they had a camera in their vehicle that was stolen.
Have you heard about all kinds of civilian cameras, Ring cameras, and other types of security that people can have at their property?
We have.
Did you look and see the immediate area to see if the Rodriguez's or the Coggins or anyone else might have had a camera set up that may have gotten this?
Absolutely. I requested several agents to do what we call a neighborhood canvas, which is where they go door to door and meet with the residents in the area to see if there's any type of cameras or any type of information they can provide that would benefit the investigation.
And is that how we got with the Coggins and Mr. Foxwell and some of the others, how they eventually were brought to you and you added them to your report?
Correct.
At the same time, when you were first there, was the suspect still at large?
When I first arrived on scene, as I was responding to the scene, the suspect was still at large. But when I arrived on scene, I heard that they had someone in custody. So I arrived about the same time that they took him into custody.
Okay. And once he was taken into custody, did you start taking aims to secure the video from McNeil to compare and see, do we got the right guy?
Correct.
Okay. During the investigation, were you able to view the surveillance of his initial theft and driving to the scene and eventually the shooting?
I was.
Okay. Based on that, did you get a description not of only his person, but his articles of clothing he's wearing during this incident?
We did.
Okay. Your Honor, this time I move to publish, once again, a little bit more complete, stage 1.
Okay.
All right. And in the initial video, are we actually able to see the initial taking of the truck back in Leon County?
We are.
And looking at kind of out the front, what is this?
That's the Hardees in Leon County where the vehicle stole from.
Okay. After getting that, did you see him pull down the mask?
Yes.
Do we then watch him drive into Gadsden County?
Yes.
Watching this video, were there articles of clothing that became of interest to you based on your crime scene?
Yes, sir.
Which ones?
The jacket, the plaid shirt, the red gloves, the white gaiter around his neck that he was using as a face mask when he first entered the vehicle. The sunglasses that he sat down after he took them off.
The next clip, do we have it working to the area of Jameson Road?
Correct.
Throughout this drive, does he ever take the red gloves off?
No, sir.
Does the car seem to operate normally in traffic and go up 30, 40, 50 miles an hour?
Yes, sir.
Throughout his driving from the restaurant to Jameson Road to his point with the deputy, does he seem to have any mechanical, any stress, anything going on that's bothering him?
No, sir. It appears that he's calm and that the vehicle is operating as it should.
And then here at the ramming, does he still have those gloves on?
Yes, he does.
You see him in that tan jacket through the driver's side window.
Yes, sir.
Do you see his right hand?
Yes, sir.
What color is it?
It's red.
Does it still seem to be the same color as the gloves we
Yeah.
see him driving with?
Yes, sir.
In this case, we've collected a good bit of physical evidence from the trail that led to eventually to him, right?
Correct.
Did we find 2 red Craftsman gloves consistent with what he was wearing?
We did.
Did we find a tan corduroy jacket consistent with what he was wearing?
We did.
Did we find a red and kind of plaid flannel shirt consistent with what he's wearing?
We did.
Did we find a blue gaiter consistent with the mask he had?
Yes, sir.
Did we find the sunglasses?
We did.
And did we find a pistol consistent with what went into the car?
Yes.
Now, in addition to your work as a law enforcement officer, have you actually had advanced training as in Glock pistol?
I have. I've received advanced training from the Glock manufacturer themselves as a Glock armor. And I also have personal experience with Glock because since 2007, I have been issued a type of Glock weapon every day in my law enforcement career and have extensive training over the manipulation, functioning, test, and evaluation, and the troubleshooting and fixing of a Glock weapon.
When we found the Glock, were there still live rounds in it?
There was 11 rounds in the magazine.
Okay. And was there an empty shell casing laying next to it?
There was.
Okay. Was there a live round in the chamber?
There was not.
Okay. Do you have an explanation based on your training experience what happened with that thought?
I do. So the Glock in question is a Glock 45. It's a semi-automatic weapon, which means every time you squeeze the trigger, the gun goes bang, and the energy expelled in that round firing, that little small explosion that causes the projectile to slide out of the barrel. Also, some of that energy sends the slide of the weapon backwards, which causes it to eject the spent cartridge and then systematically pick up the live round. So then you could again squeeze the trigger and it do it again. The way the weapons are designed is they're designed to be firmly held. And we see this in law enforcement training with people that, like new recruits that come on that haven't shot a lot or don't know or never shot a semi-automatic pistol, or they're trying to shoot them extremely fast. They tend to hold the pistol loosely in their hand. But when your hand does that rocking motion, you actually absorb into your body, hand, wrist, and arm, and into your body some of that recoil of the slide. When you do that, you take away the energy that it's designed to throw the slide all the way back. So what happens when you fire a bullet is normally longer, right? When the bullet leaves the casing, now you have a short casing. The slide has to come back far enough for that casing to expel. It's even got to come back further for it to pick up the live round, because the live rounds that's in the magazine below are longer. In this case, we had a spent casing, but nothing live in the weapon, which tells me that at some point, due to rapid fire, the weapon actually went to eject that spent casing, but the slide didn't come back far enough, and it actually hung up in the slide, not picking up a new round. So, and then once the weapon was tossed, it jarred that casing free when it hit the ground. So you have a spent casing by the weapon, no live round in the weapon, and still live rounds in the magazine.
Is that consistent with what we see when him running away, firing, if he's firing going straight, if he interests it or does not hit it with enough force, can it cause a stovepipe or another, they call it stovepipe? Is that because the brass goes straight out?
Correct.
Okay. Is that a malfunction that'll stop it from working?
Correct.
Okay. Once again, will that just hang up in that slide until it's cleared?
Correct.
Based on your experience, if throwing that into the woods, would that explain how that you'd have a shell casing without a live round in the magazine?
Absolutely.
Okay. And was there ever a live POW in the woods while those officers were looking for it?
No, sir.
Would that have been of great significance if we had started hearing gunfire coming from where he threw the gun?
Absolutely, it would have.
Your Honor, bailiff, just lost it. Okay, state's 30.
30.
Did I ask that you go and collect buccal swab from the defendant in this case?
Yes,
Okay. And is that what you're holding in state's 30?
it is.
What is a buccal swab?
So a buccal swab is obtained. It looks like a long Q-tip, and you stick it in someone's mouth and rub their cheek line and their jaw, and you're actually getting skin follicles from inside the mouth, and that's how you collect someone's DNA for a comparison for any other items of DNA value that we found on scene. That way I can specifically say that this DNA came from the individual that I physically obtained it from as a comparison.
And do you see the person that you collected that buccal swab in the courtroom today?
I do.
Okay. Could you please indicate where he's seated? What's his name?
The defendant in the blue suit.
Okay. Please allow the record to reflect the witness identified the defendant. Enter states 30 into evidence at this time.
Any objection? Without objection.
for gunnies like me, when you say a Glock 45, is a 45 a common round caliber weapon, handgun?
So a Glock 45 is fairly new to the market. It's not very common. It's one of the newer models of Glock that they make.
Okay. What I was actually referring to, if I said I shoot a 45, what does that mean in common
Okay,
parlance?
so common lingo, that would be a 45 caliber ACP weapon, which is a totally different round than the Glock 45, model 45, which is a 9mm handgun.
Okay. And that's why I wanted to clarify. So we've been referring to it as a Glock 45. That's the model number, 45.
That is the model number.
But ironically, Glock doesn't make the 45 in a 45 caliber. They make it in a 9mm.
Correct. An actual Glock that shoots a 45 ACP would be considered the Glock 21.
Just to make it more complicated.
Just to make it more complicated.
Okay. So even though we've been calling it, we're correct in calling that pistol a Glock 45, but it is that we're talking the model, the caliber is 9mm.
Correct.
Thank you. Nothing further this time.
Cross-examination.
That no, I don't got nothing. Don't worry about it.
All right. Agent Wheeler, you may step down.
Thank you, sir.
All right, State, you may call your next witness.
State calls Maria Hyatt.
Hyatt, if you would please raise your right hand. Do you swear or affirm the testimony you give in the case now and hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated.
Thank you.
State, you may proceed.
Can you please state and spell your name for us?
Yes, my name is Maria Hyatt. That is spelled Maria. My last name Hiott.
All right, and where do you work, ma'am?
I'm currently employed at the Florida Department of Law Enforcement.
And in which department or section is that?
I am employed in the biology section.
And what is your position title?
I am a crime laboratory analyst.
And how long have you been a crime laboratory analyst?
Approximately 5 years.
Now, how long have you been total with FDLE? Has it been that 5 years?
Yes.
Okay. Any experience being a forensic tech, anything like that beforehand?
No, I did do an internship with the Pinellas County Crime Laboratory for about 6 months during my obtaining my bachelor's degree. I'm sorry.
What are your duties as a DNA analyst?
So my duties include examining an item of evidence for the possible presence of biological materials. I take on samples and place them in individually labeled tubes. I develop profile from the evidence, and I also compare to known profiles, which also go through the same DNA testing process. I calculate statistics and write a report and then testify as needed.
All right, and what is your educational background?
I have a bachelor's of science from the University of Central Florida with a concentration in forensic biochemistry.
And have you received any specialized training from FDLE that allows you to be a DNA analyst for them?
Yes, I have.
Okay. What does that training entail?
So the training entailed a 1.5 year long training program where in the first phase, I read journal articles, read books on the subject matter, took examinations, both written, oral, and practical examinations. I worked on over 200 samples that I did the same DNA testing that I do on casework now. I did a period of supervised casework, and I successfully completed my training with a mock trial.
And through that, I mean, are you having to do any sort of continuing education or proficiency testing as well?
Yes, I do. I am required to undergo 8 hours, minimum 8 hours of continuing education, and I do have to take a proficiency test twice a year.
And the proficiency testing, does every analyst at FDLE in your section, do they all have to do that?
Yes.
Okay. And is this done by FDLE, or do y'all bring in someone from the outside to do it?
So when we do the proficiency testing, it is a mock case that comes in that is purchased from a third person laboratory, a third
party vendor. The answers to the tests are not known to anyone, and I work it just like I do a regular case. I then submit my answers, and it is graded by my supervisors once they receive the answers from this third-party vendor.
And you have to pass those tests, correct?
Yes, that's correct.
All right. Is FDLE Crime Lab, is that an accredited crime lab here in the state of Florida?
Yes, it is.
Who accredits it?
We are accredited by ANAB, which stands for the American National Standards Institute National Accreditation Board.
All right, I want to switch gears a little bit. Can you tell us what DNA is?
Yes. DNA stands for deoxyribonucleic acid, and it is the building blocks of all life. It is passed down from parent to child, and half of it is from your mom and the other half is from your dad. It is unique to all individuals with the exception of identical siblings, and it can be found in every cell of the body with the exception of mature red blood cells.
And what is the purpose of forensic DNA testing?
So the purpose of forensic DNA testing is to develop profiles from items of evidence and then compare to the profiles from known individuals, and then report a statistic whenever an inclusion or a match has been identified.
And where can DNA be found in the body?
So in the body, it could be found in virtually every single cell that you have. It could be found in your hair. It could be found in blood, semen, saliva. It could be found on your skin cells, pretty much every cell that you have. Like I said before, with the exception of red blood cells, mature red blood cells.
And how can that DNA, how can it be transferred from surface to surface or person to person?
So DNA's skin cells could be left behind by simply just touching an object or two objects touching each other. And so whenever you're touching the object, you're always going to leave some DNA behind. It might not be your DNA, it might be DNA that you picked up from somewhere else, but DNA can be fairly easily transferred.
All right, what can it depend on, how it gets transferred?
Yeah, there's various factors that transfer depends on. If you're wearing gloves, for example, or a barrier, that could deter the amount of DNA that you transfer. If you have recently just washed your hands, then you might not have much DNA on your hands, as opposed to a person that's like sweating and touching their forehead a lot. They're going to have their hands charged essentially with a lot of DNA, and that could be left behind. If the surface that you're touching, the type of surface, if it's rough or if it's smooth, how long something has been touched, all of those factors go into how much DNA can be transferred to an item.
All right, and what determines how long DNA survives?
If an item of evidence is properly stored in a cool environment, DNA can virtually last a very long time. But if that item of evidence is exposed to the elements, so sun, heat, moisture, rain, any of those things, it could degrade that DNA or destroy the DNA that is left behind on that evidence.
Right, and what is STR testing?
STR testing, that is the testing that we do at FDLE. It stands for short tandem repeats, and it is the areas that we look at in the DNA. It's those unique areas that we look at. We look at 21 different areas, and they're just short areas of that DNA that repeat in sequence in a head to tail fashion. And the amount of repeats that you have is your type or your profile for that specific location.
Now, how would you go about obtaining a DNA profile from a piece of evidence?
So when I first look at a piece of evidence, I look at it visually. I see if there's any staining. If there's any staining, then I take, if there's any staining that is present, I then test it with chemicals to try to determine what possible bodily fluid it could be. Or if I don't see any staining, I may just take a swab for those potential skin cells. After I take my sample for DNA, I place them in individually labeled tubes to which I apply chemicals and heat in order to break open the cells and release the DNA into the solution. After I do that, I see how much DNA is present in the sample. And if there is enough DNA present, then I take it on to the next step where I make millions of copies of those short little areas that I'm looking at. Finally, it goes through one final instrument where that DNA gets separated and it gets detected, and it comes up on my screen like peaks on a graph.
Right. How many samples would you have open at one time?
At one time, I only ever have one item of evidence open. If we're talking about the tubes, then I only ever have one tube open at a time when I'm adding my chemicals.
So are these, I guess, measures that you put in place to avoid cross-contamination?
Yes, I ensure that the item of evidence doesn't get contaminated by following my standard operating procedures. Additionally, we also have positive controls and negative controls that I run in tandem, so at the same time with my samples that I take from the evidence, in order to ensure that my results are reliable.
And I've got a box of blue gloves in front of me right here. Do you wear something similar to this when you handle evidence?
Yes, I do.
What are markers or locations? What does that refer to?
So that refers to those SDRs, or that location of the DNA that I'm looking at. With the technology that we have, we look at 21 different markers plus 3 gender markers.
And what do you consider a match?
So a match is just when I have a known standard and the profile from the known standard matches or is the same as the profile from the evidence.
Would that be all 20 markers or 21 markers, including the 3 gender markers?
It depends on the evidence that I have. If I have I could have sometimes where I don't have enough of all of those 21 areas, but whatever areas are there, if they are the same or consistent with the profile from the known individual, then it's still considered a match.
And is the SDR testing that we've been talking about, is that the standard procedure used by FDLE?
Yes, yes it is.
And is that procedure, is it peer reviewed and published on?
Yes it is.
Have you received any training in statistics during your time at FDLE?
Yes, as it relates to my job.
Right. What is a likelihood ratio?
So a likelihood ratio is just a statistic that I calculate to show the weight of a match or an inclusion. It is 2 different hypotheses or scenarios of how the DNA could have originated. And it shows which of those scenarios might be more likely.
Right. And do you routinely make these calculations while you're working at FDLE in this type of analysis?
Yes, I do.
And when do you use it?
So whenever, like I stated before, whenever I see that the profile from the evidence and the profile from that known individual, they match, or that known individual could have contributed their DNA to the profiles that I obtain, at that point is when I calculate a likelihood ratio.
Right. And the formulas that you use to make these calculations, are they widely used and generally accepted?
Yes, they are.
Are they peer reviewed and published on?
Yes, they are.
And can you describe to us how you would perform this statistical analysis?
So essentially, I take the profile from the item of evidence, the profile from that known individual, and I input it into a software tool, which is just a big calculator at the end of the day. And I tell it my propositions or my scenarios, excuse me, and then it calculates that statistic for me.
All right. How many DNA samples have you tested during your time at FDLE, if you can estimate?
If I were to put a number on it, it would probably be into thousands.
Have you ever testified as an expert in DNA analysis?
Yes, I have.
How many times?
About 5 times.
Right. Your Honor, this time, those are all the questions I have as to this witness's qualifications to give opinion testimony.
Do you wish to voir dire the witness on her qualifications? Yes. All right, you may proceed, counsel.
All right. Did you receive a buccal swab in this case?
Yes, I did.
Okay. What is a buccal swab?
So a buccal swab is just a swab that has a cotton tip at the end, like a Q-tip, and it is a swab of the inside of the cheek. We like to take the buccal swab as a standard and use it as a standard because it has your buccal or your cheek has a lot of cells there.
And if I could ask the bailiff to grab States 30 for us. It's already been admitted in evidence of States 30.
probably 125 too.
Yes. Yes. Do you recognize that?
Yes, I do.
Okay. And how do you recognize it?
I recognize it because it has the FDLE yellow barcode as well as my seal with my initials and the date of when I examined this item of evidence.
Right. And from whom is this? Was this buccal swab taken?
It is said to be from Dexter Lawson.
Now, you also, if I could ask you to come grab what's been admitted into evidence as State's Exhibit 25. Did you also receive swabs from the grip and trigger of a Glock 45? I believe that's items number D1, 1 and 2, or D1, D11, something like that.
Yes, I did. D11-2.
All right. Was a full DNA profile developed from the buccal swab?
Yes, it was.
Okay, is that expected and normal?
Yes, it is.
Now, these items that you have, are they always in separate envelopes?
Yes, they are.
And do they ever touch each other?
No, they don't.
So State's Exhibit number 25, did you perform the swabs from the firearm? Did you perform testing on that item?
Yes, I did.
All right. Did you develop a profile?
I obtained a mixture of 2 donors, consistent with 2 donors, and including at least 1 male contributor.
All right, and did you compare that profile to the profile obtained in State's Exhibit number 30, item number 28, the buccal swab of Dexter Lawson?
Yes, I did.
Okay, and what were the results of that comparison?
So there was not enough statistical analysis to determine that he could have contributed his DNA to the profile that I obtained from the swabs from the gun.
So basically no determination could be made.
That's correct.
If I could ask you one more time, it's either State's Exhibit 17 or 18, the open glove.
Thank you.
Maybe if you can just open that package up and look at it.
Okay.
All right, can you see what that is?
Yes,
Okay, what does that appear to be?
it appears to be a glove.
Okay. Someone wearing something like that while handling a firearm, would that potentially inhibit the ability for DNA to be transferred to that firearm?
Yeah, it definitely could.
Moment to confer, Judge.
No, you're good.
Nothing further.
Cross-examination?
Yes, ma'am. Is it a possibility that is it like I want to ask you? I know that the gloves you can't get your DNA on that if you got on gloves, right? But if the gun is yours, why would you wear gloves with that gun?
So I can't tell you how DNA could have gotten on the gun, and I cannot answer as to why you would be wearing gloves with a gun.
But just because you got on gloves, that don't mean if that's your gun. Just because you got on gloves, that don't mean that your DNA ain't on that gun, is it?
No, I can't testify as to how DNA got on the gun. There's many possibilities as to how DNA got on the gun. It could have been transferred from the gloves from somewhere else, or it could have just already have been on the gun. But in this case, I can't tell how that DNA that I obtained from the gun got onto the gun.
If I had that gun and if I had, did you just do a testing on? Did you just swipe the gun and test my swab with that? That's all you did?
No, I didn't actually swab the gun. The gun was swabbed by Senior Crime Laboratory Analyst Amy George. All I did was cut those swabs and then develop my DNA profile, take it through my DNA testing.
Did they test the bullets too? Like the shell that they found, did they swab that also? Oh, you don't know.
We do not do any DNA testing on fired bullets. And the reason for that is because when a bullet is fired, there's a little explosion that is happening. So all of that heat, like I stated before, can degrade or destroy that DNA. So it's not a good source of DNA for us. So we don't ever work cartridge cases from the gun.
So y'all only swab the handle of the gun and the trigger?
Again, I didn't swab the gun, but it is said to be from the textured portions of the grip and the trigger.
Can I wipe out DNA if I got on gloves?
It's possible, yes.
So by me having on gloves, I can just wipe out the DNA. I ain't got to intentionally wipe it off.
Yeah, if you're wearing gloves, again, you could leave DNA or you could pick up DNA. So it's possible that DNA that was there could have been rubbed off from the gloves.
Is that it, sir?
That's it.
Redirect?
No, sir.
All right, Ms. Hyatt, you may step down.
Thank you.
David, call Jeff Foggy. Madam Clerk, 10, 11, 22, 23, 24.
Sir, if you would please raise your right hand. Do you swear or affirm the testimony you give in the case now and hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated.
Yes, sir. He's gonna need those. Good afternoon.
Afternoon.
Could you introduce yourself to the jury?
My name is Jeff Foggy. Last name is spelled Foggy.
What do you do for a living?
I'm a senior crime laboratory analyst assigned to the firearms section at the Florida Department of Law Enforcement in Tallahassee.
How long have you been doing that kind of work?
I've been with FDLE for 23 years, approximately 16 in the firearms section.
What type of education and training do you have to get you qualified in that section?
I have 2 degrees, one in chemical sciences from Florida State University and one in forensic science from the University of Central Florida. Aside from that, I also have approximately 2 years of internal training in the area of firearms identification at the Florida Department of Law Enforcement.
What is the firearms section at FDLE do?
My primary functions are to examine firearms to determine if they function properly and safely. I also microscopically examine fired bullets and fired cartridge cases to determine if they can be identified to or eliminated from each other or to a particular firearm.
Have you had the opportunity to do actual casework over the last 23 years?
Yes, sir.
Okay. Approximately how many times?
Thousands of cases.
Have you had the opportunity to give opinion testimony in courts, federal and state?
I have.
About how many times?
For the state, almost 200 times.
I would tender the witness at this time.
Any questions as this was qualifications? All right, you may proceed, Mr. Campbell.
What's a firearm?
A firearm is a tool that's designed to expel a projectile by means of an explosive force.
And I've asked the bailiff to give you what's been pre-marked and entered into evidence as states 10, states 11, states 22, states 23, states 24. Can you take a moment to look at each of those?
Okay.
Do you recognize them all?
I do.
Okay. And did you have an opportunity to work with each of them?
I did.
I would like to first call your attention to the box, which I believe is stage 23. What's in there?
Contained within this box is a Glock 9mm Luger caliber semi-automatic pistol, model 45.
Your Honor, with your permission, I'd ask that the witness be allowed to open it. I don't know if the bailiff wants to safe it.
Is he a sworn officer? Yeah, I need to have.
He is a
those.
sworn officer.
Okay, as long as the sworn officer is checking it clear.
I had to ask that. Are you also a sworn law enforcement officer?
Yes, I am. Your Honor, firearms safe.
Thank you, Your Honor. Can you now is it capable of taking it out of that box so you can show it to the jury?
Yes, it is.
Please do so. All right. Now you said that that is a 9mm Glock. Is that correct?
That's correct.
Can you explain how that type of weapon fires?
Sure. This is a semi-automatic firearm. And what that means is you'll put the rounds of ammunition or bullets into what's called a magazine, cartridge magazine. You'll then place that into the firearm. You'll then work the top of the firearm called the slide. That'll load a round of ammunition prepared to be fired. When you pull the trigger, that round will be fired. The bullet will go down the barrel. The cartridge case or spent cartridge case will be ejected and expelled from the firearm. The firearm will then, the top of that firearm will then move back and forth and reload the firearm, preparing it to fire again. Every time you pull the trigger, you'll get one shot. You have to release the trigger and pull the trigger for each shot you fire. This will do that until you quit pulling the trigger or until the gun is empty.
Is there also various types of malfunctions that can happen with a weapon like that?
Sure.
Have you ever heard the term limp risking or failing to hold the pistol solid enough to cause a stovepipe malfunction?
Yes, sir.
Can you explain that? Sure.
If you're not holding it tightly enough, what can happen is as that slide, that top portion goes backwards. You're not holding it tight enough, giving it a firm grip, it fails to go all the way back. So the fired cartridge case may get stuck in what's called the ejection port. And if I may show the portion right here is called the ejection port, the open portion. It'll get stuck in there and stick out and get caught in the firearm, and that's called a stovepipe.
And as a sworn officer, y'all taught how to clear that quickly and continue to fire the weapon?
Yes.
What's the maximum, did you also receive a magazine?
I did.
How many rounds of ammunition can that pistol carry?
For this particular magazine, it had a total capacity of 17, which means the total this pistol can hold is 17 in the magazine and 1 inside the firearm, so 18 total.
All right. And how many live rounds were sent over with that?
Let me refer to my note. The packaging states that there were 11.
11. All right. So if that was fully loaded in chamber and fired 6 times until they had a malfunction, would that account for the full 18?
If there were 11 and it was fired 6 times, that'd be 17.
Okay, sorry, pardon me.
It's okay.
Not good in math. So that would give you the 17 that would fill the magazine.
Correct. So that would be a full capacity magazine.
In addition to that, were you provided with some projectiles, or sometimes called bullets?
I was.
Okay. Can you explain how for the jury, a full round of ammunition is constructed?
Sure. A full cartridge, or what a lot of people call a bullet, it's actually one unit of ammunition. So it has a bullet on the top. It has a cartridge case that holds the bullet. Inside that cartridge case is gunpowder. And then on the back of that cartridge is what's called a primer, and that's the ignition source. And what happens is when the gun is fired, the primer is struck, there's a spark, it lights the gunpowder on fire. A lot of pressure causes the bullet to go downrange. The gunpowder is consumed. The cartridge case then leaves, and this particular firearm leaves the firearm once it's fired.
In this case, did you get several items that are consistent in size and shape with being that projected projectile?
I received, I believe, 4 possible projectiles.
Okay. And what were the general condition? Were they all in good condition, bad condition?
They varied.
Okay.
They were all fired, but they varied.
Okay. What do you often see projectiles or bullets in various levels of decay?
We do.
Okay. Why? What happens to a bullet once it goes and hits things?
Well, it depends on what it hits. If it hits something hard enough, it could destroy the entire bullet. If it hits something soft, it may be fully intact. It just depends on what it hits.
Okay. So a bullet that's shot through glass, is it generally that less resistant than hitting into a piece of metal?
It depends on the metal.
Okay. Did you look, as part of your training in science, are you able to sometimes make comparisons between the projectiles that have been collected in evidence and a particular firearm?
Yes, sir.
How do you do that?
When a firearm is manufactured, the tools that make that firearm will leave random microscopic imperfections on the inside surfaces. So when you fire the gun, the bullet or the cartridge case will come into contact with those imperfections, and in some cases may pick up those imperfections. What I can do is in the laboratory, I have what's called a comparison microscope, and that's two microscopes side by side with one field of view, and it's got varying magnification. And what I can do is I can look at those markings created by that firearm on the bullet or on the cartridge case and come to a determination as to whether it was fired from that particular firearm or whether it was not fired from that firearm.
Okay. Now, to be able to do that, do you have to create some standards through that firearm?
I do.
And did you actually test fire the pistol you've shown this jury?
I do. As part of our normal testing, what I'll do is I'll fill out an information worksheet on the firearm, verify that it appears to be functioning properly. I'll then go into our indoor range and conduct test fires. What that allows me to do is two things. One, verify the gun does work properly, and secondly, get those standards to see how that gun is marking.
Okay. And was that a fully operational and good shape pistol?
Yes, sir.
Okay. And did you get some standard projectiles from that testing?
I did.
Okay. Did you compare those with the 4 projectiles that were provided to you in this case?
I compared it with 2 of the 4, yes.
And were they, were you able to see sufficient markings on those projectiles to make any conclusions?
For 2 of the projectiles, I could make a conclusion that there was no value for a comparison. However, they did have some value. And on 2 of them, there were markings that allowed me to compare it to my standards.
Okay. And once again, for the projectiles, what was the result of those comparisons?
For 2 of them, again, there was no value. However, they were consistent with being fired from a Glock. With the other 2, my determination was they were inconclusive. And what that means is they had some general features of the firearm. However, the features I need to make an identification weren't present in order for me to make an identification.
Is that unusual with Glock brand firearm?
It's not.
Okay, why?
The manufacturing process for Glock uses a very good process to make the inside surfaces of those barrels, and sometimes the bullets don't come into contact with those imperfections.
And so, in your expert opinion, could that gun have fired each of those 4 projectiles?
For 2 of them, I definitely made a comparison and was inconclusive, so I couldn't tell you whether it was one, but it could have been. The other 2, even though there's no value for microscopic comparison, they were fired, in my opinion, from a Glock.
Okay. So 2 of them were definitely fired by a Glock. 2 you don't know for sure, but you can't say definitively any of the 4 were fired from that Glock.
That's correct.
Okay. All right. So that's for the thing that goes downrange, including the one that was removed from her breast, correct?
Correct.
Okay. Now we have this cartridge case that's ejected. Did you get some of those?
I did.
Okay. How many of those did you get?
I received 5 fired cartridge cases.
Okay. And what are you able to do with that?
Like the bullets, I was able to compare them to the standards I made using the comparison microscope.
Okay. And with the you described earlier, the firing pin hits that primer and starts the explosion. Is that right?
That's correct.
Okay. Are there imperfections on that firing pin that allow you to compare how it strikes a piece of it and allows you to make comparisons?
For a fired cartridge case, there's numerous areas that the firearm touches when that unit of ammunition is fired. That primer area is the main focus during firing with a Glock.
And did you make comparisons between the shell casings and the standards you made in your lab?
I did.
Okay. And what was the result of those?
It's my opinion they were fired from this pistol.
So that pistol shot the shell casings that were recovered from the evidence at the shooting scene?
In my opinion, yes.
Okay. Thank you. Nothing further this time, yeah.
Cross-examination. All right, thank you, Mr. Foggy. You may step down. As far as, do we need to secure the weapon? Do we have a clear box with a lock on it, or are we gonna re-secure it in the box?
I don't think we have one in here, so I'm fine securing in the box or however the sheriff feels necessary.
Yeah, we'll go ahead and re-secure it in the box, and the deputy will take custody of of state's 23.
Thank you. That's all.
State, you may call your next witness.
This time, state the rep.
All right, let's see. All right, ladies and gentlemen, the state has rested its case. At this time, the parties and I need to take up some matters outside your presence. This should take about 10 minutes or so. So what I'm going to have you do, we're not done with the case, so just leave your notepads face down, and we'll have you head back to the jury deliberation room. Again, don't discuss the case, and we'll get back with you in the next 10 minutes or so.
All rise for the jury.
All right, the jury is departed the courtroom. Everyone may be seated. All right, at this time, the state has rested its case. At this time, does the defense have any motions to present? Okay. Now, Mr. Lawson, normally at this time, I give you time for you and your defense counsel to discuss whether or not you intend to testify, but I'll let you have some time if you wish to think about it on your own, because you and I are going to talk about your right to testify. Would you like to go ahead and take a couple of minutes and think about that on your own while we take a brief recess?
Yeah.
All right. With that, why don't we take about a 5-minute recess?
Thank you.
Court being recess.
All rise. Court is now back in session.
Everyone, please be seated. All right. Mr. Lawson, have you had enough time to think about whether or not you desire to testify?
Yes, sir. Before I answer that question, right? Is it too late to bring another motion up on you? I mean,
you can make a motion whenever you need to make it.
Well,
I'll see whether it's timely or not.
Okay,
What motion do you have, sir?
I was saying my right arm is handicapped. I'm left-handed. I just wanted to add that to the record, but
what do you mean by add that to the record?
I just wanted to make it known because they saying.
Well, make it known to whom? Because the jury's not in here. And in order to make that part of the evidence, and this is what we're going to get into talk about, that has to be in evidence somehow. And the only way to get things into evidence is all these things. We've got states 1 through 19. We got states 21 through 25, states 27 and 28, states 30 and 31. Those are in evidence. And the testimony of people that got on this stand is in evidence. That's all that's in evidence. So in order to get that, you'll have to have a way in your case in chief, and we're going to talk about that in a moment, to get that information in front of the jury. That could be by testifying. You could testify, or you could have somebody else testify. You could properly enter records into evidence or something. But in order for the jury to know about it, it's not just you saying it from that table. It would have to be you saying it, testifying under oath, subject to cross-examination by the state. Okay. So I can't answer your question on. There's not really a motion there to the extent that it's what is it a motion? I'm not taking judicial notice of the status of your right arm. I'm not doing that.
Right.
So
I'm good. I don't want to testify neither.
You do not want to testify?
No, sir.
All right. Do you understand you have the absolute right to testify?
Yes,
you have the absolute right not to testify. And if you choose not to testify, I will give the jury, if you so desire, the right to remain silent instruction. It's similar to the one I gave before, that they can't hold that against you. But also understand, and it's kind of along the lines of what we just talked about, that, and I told them at the beginning of this trial that what the attorneys say, including what you say as your own attorney, is not evidence. Now, if you decide to testify, you can or you don't have to.
if you decide to testify, what you say on that stand is evidence. Now, it's subject to cross-examination. They can decide whether to accept it or not accept it, like any other evidence. Because you've had my draft jury instructions. Those aren't final, but you understand it said that they can believe as much or little of the evidence as they so choose. They can believe any or all of what a witness says or none of what a witness says. Yours would be treated the same. You've seen that I also had in that draft jury instruction, if you don't testify, they can't hold that against you. But if you do testify, that they're to treat your testimony like they would any other witness. Understanding that, has anybody forced you in any way or promised you anything to give up your right to testify in your own trial?
No, sir.
And are you doing that of your own free will?
Yes, sir.
All right. And do you have any other witnesses or evidence you intend to present in your case in chief?
No, sir.
All right. And hearing that you had said no, sir, it was a bit light. I'm not sure if the court reporter got it, but I'm making sure it makes this record. Then my intent would be I'll call back in the jury in a moment. I'll say you may proceed, at which point you would rest your case in front of the jury. I'm then going to send the jury home. It's now almost 4:10 p.m. We still have to talk about our final jury instructions. So we'll go ahead and send them home for the night. We'll tell them they're not, they can't deliberate yet. And we'll have them come back at 9 a.m. tomorrow morning, at which time we should have our final jury instructions all ready to go, our verdict form. And then what we'll do when they come back in tomorrow morning is at that point, we'll go ahead and give the court will give instructions on the law. I will then allow Mr. Campbell to give his closing argument. Mr. Lawson, I'll then allow you to give your closing argument. And then Mr. Campbell will be allowed to do a rebuttal argument pursuant to the Florida Rules of Criminal Procedure. At that time, I'll give those final instructions to this jury. I'll charge them to go back and start deliberating on this case, and they will decide the facts in this case. So with that, are there any other matters we need to talk about before we bring in the jury?
No, sir.
Yeah, sure.
All right, let's bring in the jury.
All rise for the jury.
All right, ladies and gentlemen of the jury, you may be seated. Everyone else may be seated. Defense, will you be calling any witnesses?
Yes, sir.
The defense, you rest?
Yes, sir.
The defense has rested. So ladies and gentlemen of the jury, we're at that part of the trial now that all of the evidence has been received. The parties and I have to finalize your final jury instructions. Based on the hour, I don't want us to have to do that. That'll take me 20, 30 minutes. Then we got to do close. I got to instruct you on the law. Then the parties got to close. I don't want to hold you that late. I told you this was likely a 3-day trial. This is the end of day 2. So what I'm going to do is I'm going to send you home tonight. And then I'm going to have you come back and we're going to start afresh at 9 a.m. What that'll allow you to do is go home, relax, energize. Don't talk to one another about the case. Don't talk to anybody else about this case. I'm going to give you that same instruction I've given you. You're not going to study anything, but you're just going to go home and you're going to relax and you're going to rest. And that way, tomorrow morning, we're going to have you come in at 9 a.m. I'm going to instruct you on the law. And then the state will give its closing argument. The defense will give its closing argument. And the state will get a rebuttal argument. At which point I'll give you the final instructions, and then I'll dismiss the alternates and have the 6 jurors go ahead and deliberate this case, but not until then. Okay. So you've been here in that receive mode. Well, tomorrow that's why I want you to go home and rest up, because tomorrow
becomes the really difficult task that you have. And that's for you to talk with one another, deliberate, and decide what the facts of this case are. So with that, ladies and gentlemen of the jury, I am going to give you that instruction again. This case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. So with that, ladies and gentlemen, again, they may tell you a little bit earlier time to get you in that room. I'm going to need you at 9 a.m. That way they can figure out what time they need you. Have a very restful evening.
All rise for the jury.
All right, the jury is part of the courtroom. Everyone may be seated. All right, so state defense, I'd like to go ahead and talk about the proposed jury instructions. The way I like to do this is I like to go page by page. There's a couple things I want to mention. Initially, they're not in there that I did notice as the conduct of the trial went on. So I'll mention that first and where I think would be the applicable place. Mr. Campbell.
I think Mr. Lawson may not have his copy, so I think we may need to make another copy for him.
We can do that. Does your office have the ability to do it quicker? I can run upstairs and do it.
I think there's a copier right outside that ground door, if we can. I believe this is the most current one.
I haven't changed anything since the one we got Monday morning, so.
I should have this one. Then I'll step out and make copies.
All right. We'll be in a brief recess in place. All right, we're ready to go back on the record?
Yes, sir.
All right. We're back during the brief recess. State attorney made a copy of the proposed final jury instructions for the defendant. He had not come in with his copy today. These have not changed since the ones that we did Monday. The first big picture I'll note is that, and I'll hear from the parties on it, it would appear that the eyewitness identification instruction may now be applicable based off the testimony, and that's specifically standard instruction 3.9 C as in Charlie, but that is if it's requested. This was not a lineup, so none of the lineup portions would be applicable. So I'll hear from the parties regarding eyewitness identification.
Just, you know,
And normally that would go after defendant's statements, which is currently defendant's statements is on page 22 and 23.
let me look at that standard instruction, please, sir.
3.9 C is in Charlie.
I'm fine with it being in there. I'll leave it to the defendant's request. I have no objection either way.
All right, Mr. Lawson.
22 and 23.
Well, it's something that would be added after the defendant's statements on page 22 and 23. It'd be after that, it would be the eyewitness identification instruction, standard instruction 3.9 C. Are you requesting that instruction or not? Are you waiving that instruction?
So requesting the instruction.
Do you request me to give the eyewitness identification instruction, or do you want to waive the identification? Meaning you don't want me to give it?
Right.
You don't want
No. Okay. The court will not give it based on the request by the defense's request not to give it. Okay. So with that, we'll go to page 1. Anything on page 1? State?
No, sir. Once again, it's highlighted of law enforcement. Just need to take that out, but otherwise I'm fine with it.
Oh, maybe I did do some changes then. All right. Because I had taken that out. So
Okay, so it's highlighted in my copy and the one I just made for him.
Good. The court has taken that out.
Okay, so that's stricken of a law enforcement officer on both introduction of. Okay, no otherwise. I'm fine with it, Your Honor, as it is.
Mr. Lawson, any changes on page 1?
Oh, sorry.
All right, page 2, state,
No objection.
defense.
No, sir.
All right, page 3. On page 3, before I ask the parties, I will note my intent, and I have it highlighted on there, my intent on both counts 1 and 2 were to identify count 1 as vehicle, as charged in the information, count 2 as firearm, as charged in the information. Is there any objection by the parties to that delineation?
No, sir. I think you do need to clarify which count, and that's the clearest one to do it.
Any objection, Mr. Lawson?
No, sir.
All right. It would appear that it would appear to the court that there is not a heat of passion instruction warranted. State?
I agree, Your Honor.
Mr. Lawson? That's the highlighted portion on the bottom of page 3.
Said there is no heat of passion. You said the instruction was there isn't heat.
There is no evidence giving rise to the heat of passion defense. If you believe there is, I need you to cite what evidence, what information came into evidence that would.
So I had to testify in order to add the heat of passion to the jury.
I didn't say that, sir. I just need to know the state and the defense have now rested their cases. All evidence is in this case. Now I need to know what evidence has raised certain defenses, if any.
I mean, if you saying that anything that I said is not considered evidence, then I guess ain't no evidence that show heat of passion.
All right. Okay. Anything else on page 3, state?
No, sir, that's correct.
Defense?
No.
All right. Anything on page 4? Again, the vehicle, we'll put that in there. Anything else on page 4, state?
Just need to take off, once again, the rest of the heat of passion on page 4, but otherwise, that's it.
Defense?
I mean, the heat of passion, I mean, if I gotta add that to it, so if I don't add that to the evidence, then y'all can take it out of the instruction. Is that what you're saying?
I'm not saying anything about anybody adding anything to the evidence. I'm saying the evidence is closed in this case. There is no more evidence to be taken in this case, and therefore I now need to look as a matter of law at what evidence came out in this trial, and the court does not see, and the court invites the parties to let me know if they see something that I didn't, any evidence that raised the heat of passion defense.
No, sir.
State agrees that there's been no evidence of any, once again, that there was no defense case, nor there was ever any testimony about a provoking heat of passion act that would justify that instruction anywhere.
All right. So anything else on page 4 from either of the parties?
No, sir.
Mr. Lawson?
No, sir.
All right. On page 5, again, no heat of passion defense. That's the majority of page 5 and the top of page 6. Anything else from the state on to page 5?
Not on page 5, sir.
Defense?
So I'm having okay. So you saying like you taking the instruction or heat of passion? So you saying I'm covered for one? It's like,
Sir, what I do when I put my instructions together is I kind of put as much as possible. It's easier for me to delete things than to add things. So I put a lot of possible, and this is the way the standard jury instructions are actually promulgated by the Florida Bar and the committee that works on these standard jury instructions. One of our circuit judges, Judge Frank Allman, is a member of that committee, and it's a member of judges, and it's a number of attorneys who both from the state attorney's offices around the state, public defender's offices, and private practice attorneys who all get together to draft model instructions that may apply. And so they're very broad. And then after the court receives evidence and the evidence is closed, the court will go back and look at which of those instructions apply and remove those that don't. That's the process we're in right now. Anything else on page 5?
Nothing from the state.
so let me get it right. So y'all finna re-instruct the jury to rule out heat of passion?
No, sir, I'm not re-instructing. I haven't given this jury any instructions on the law. They haven't been read any of these instructions yet. These are the instructions that when they're finalized, I am going to read them these instructions tomorrow. They're going to get an independent copy, each and every one of them, and those will be my instructions on the law. They will then take those instructions that I've given orally and that they have in written form. They will take them back to the jury deliberation room with them to aid them in their deliberations so that they don't have any questions on what the law is. If they have questions on what the law is, they will submit a question to me and I will answer their question to make sure that there are no questions about what the law is. If they've got questions about what the facts are, well, that's their job. They decide the facts, and that questions about the facts may end up being reasonable doubt. I don't know, but
I'm going to instruct them that they shouldn't have any questions on what the law is. That's a question they will.
I guess I don't
Okay.
understand.
All right. As to page 6, the court does not find any evidence of it indicating a procurement of commission of an act. Therefore, that portion of court would find to be inapplicable, as well as the definition of procure. Anything else from the parties?
No, sir.
Mr. Lawson?
No, sir.
In paragraph 7, I've included the Clark language. I've even taken out the reference to Clark v. State. That is the striking something other than an actual body of a person. In fact, the example they give is striking an occupied vehicle, which is exactly what we have in this case. So the court finds the Clark language to be applicable, but it does not appear that the Fay language would apply. Do the parties concur, and anything else on page 7?
No, sir. I agree with the court's ruling on those issues.
Mr. Lawson?
I guess.
All right, on page 8, the court's thought about this, and the court wants the opinion of the parties as to the bolded attempted murder reclassification language, because the way the court has dealt with other enhancements, permutations, so to speak, is through interrogatories without a actual reclassification headline. So the court wants to know the parties' thoughts on whether that headline bolded in all caps should remain in the jury instructions. I'll hear first from the state.
Your Honor, I think based on Apprendi and this, I think that the safest way is to do specific jury findings. I agree with that. The reclassification doesn't, I don't want to make it, I don't want them to think that it's worse or anything. So I would be fine if the style be changed to additional findings or something like that, where it's not a reclassification, which has the suggestion of basically it's worse if you do this to a law enforcement. But to me, in my review, they definitely want us to find, and I'm required to prove beyond a reasonable doubt 1, 2, 3. And so I want that to be explicit that, and I agree with the court, it would be a lesser if I didn't prove 1, 2, 3, which for the record, that the victim was a law enforcement officer, that he knew that the victim was a law enforcement officer, and that she was engaged in the law performance of legal duty. So I understand it's kind of like burglary or theft, where it's first you show that there's a theft, and then we start getting into the value of the property or the nature of the building. That seems to be what the court's doing. If the defendant wants to call it something different than reclassified, I don't have any problem, but I do think that it needs to be explicit that the state's required to find them to prove those elements beyond a reasonable doubt, which is what you've said in the.
But that's what it says, and I'm just saying, do we need that title, that attempted murder reclassified? Can we leave that out? The question is there. If you find Dexter Lawson guilty of attempted first-degree murder or attempted, I found a typographical error, second-degree murder, you must also determine if the state has proven beyond a reasonable doubt 1, 2, and 3.
No, sir. I don't think that the title is necessary, and it has some implications that I'm fine with it being stricken. If you feel like you want a title, something more generic, like additional findings, may be cleaner, but I don't think it's necessary at all. Candidly, in closing, I'm going to explain it to them.
Well, my thoughts, and then I'll hear from you, Mr. Lawson. My thought was to take it out and not, again, I'm asking them specific questions that they need to find, whether you've proven certain things beyond a reasonable doubt. And I don't want it to be aggravating by the title itself, because there's other things in there that are enhancements that they could find attempted homicide of some sort without finding the law enforcement officer individual elements, and there can still be
we know 1020 life provisions that apply that I'm asking them to weigh in on anyway. So,
Yes, sir.
all right, Mr. Lawson, your thoughts?
I ain't got no.
Okay. The court on page 5 also employing agency doesn't appear to be applicable in this case. Do the parties concur?
Right, on page 8, yeah, sir, I agree.
Mr. Lawson? Yeah. All right. Anything else on page 8? State?
No, sir.
Defense?
No.
All right. On page 9, again, I'll include the firearm in the title there. Anything on page 9? State?
Just remove the heat of passion, but otherwise I agree.
All right. I'm thinking I've got, and maybe mine got off a little bit because I did tinker with it. I've got heat of passion at the top of page 10. But anything else, page 9?
No, sir.
Mr. Lawson? Is that a no? Or are you still looking?
I mean, if it's not in the instructions, then I don't agree with that. Like, cause the heat of passion. Okay, you taking it out of the instructions of the heat of passion.
All right. So explain to me why, based on that, what evidence has raised that defense that shows that there has been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act that constituted the attempt to cause death, and that you were in fact so provoked and did not cool off before you committed the act that constituted the attempted death. Again, I'm not saying I have to believe it or not, but where is there any evidence that satisfies all of those? Because that's the legal requirement for me to give the instruction.
What I'm saying is, like, y'all talking about taking it out. I mean, it's up to the jury overall. You instructing the jury to say you basically forcing the jury to rule a certain type of way when it's up to the jury at the end of the day. Why are y'all taking that particular part out of the instruction? Y'all instructing the jury to rule out heated passion when it's all the way up to the jury on how to decide. Y'all trying to railroad me or something, man. I don't understand that.
Sir, in order to give, this is an affirmative defense, and under Florida law, you have to have some evidence. I'm not saying it has to be the best evidence, but there must be some evidence. So what is the evidence that came out that show that any of these apply? The jury can still decide you're not guilty. They still can decide there's reasonable doubt. The issue is whether there's a heat of passion. What evidence is there that
y'all just told me in order to the only way I'll be able to eject evidence if I testify.
No,
so I might want to testify then, but it's too late, huh?
It is too late.
So why are you asking me about? Am I straight with it? You know I ain't straight with it because I didn't know. I don't know this though. But you know I don't know this. So what is you talking about? What is you asking me?
Well, again, sir, I'm treating you the same as I would.
You ain't treating me the same. You treating me different,
sir. I let you speak, and I let you finish your thought, and I'm going to do the same, and I'm going to expect that that level of respect. I'm going to give you that level of respect. I'm going to let you speak, but I have to give instructions based on the law. And you might say, well, but Judge X, Y, and Z came out, and I might say, you know what? You're right. They did say that. It's not up to me to decide whether this defense will work. It's up to me to decide whether there's any evidence that would show these. And I don't remember any of it, and I've looked at my notes and don't see it. So if you remember something that came out in evidence that does trigger this defense, meaning meets those elements, it's just got to be what's called a scintilla of evidence, just some evidence that came out that would trigger that, I would give that instruction. And that's why I'm asking what that evidence was. And if you don't have it, you don't have it, and I won't give the instruction.
can't win. I can't win.
All right. Then the court will remove the heat of passion instruction. All right. As to, again, then the rest of page 10 and page 11, again, the heat of passion will be gone. Anything else in respects to 10 or 11? State?
No, sir.
Defense? And the defendant is shaking his head no. Is that correct, sir?
I guess.
All right. Then as to page 12, attempted manslaughter by act, the court did not find any evidence of procuring the commission of an act, nor the applicable definition. Do you concur, State?
Yes, sir.
Defense?
Yeah.
All right. As to the page 13, the lesser included of aggravated battery. State, looking at the information in this case, what is the appropriate, what is the theory of liability based on the charged information as to the aggravated battery? Is it the 1A, 1B, or is it both?
The state would suggest both. I would just ask for or between 1 and 2.
All right, so the touching or striking is the shooting her with a firearm, and then you've got the language of causing great bodily harm, so A or B?
Yes, sir.
Mr. Lawson?
I don't know, Judge.
All right, the court's going to give one, it'll be, I got a numbering problem. All right, we need to renumber those 1 and 2. It continued on from the previous numbering. All right, I'll give A or B. Again, the court doesn't see the Fay language being applicable, but the Clark language is. Do the parties concur?
I do.
Mr. Lawson?
Yes.
All right, as to battery, the lesser included a battery on page 14. Again, that will be 1 or 2.
Yes.
Fay not being applicable, Clark being applicable. Do the parties concur?
Yes, sir.
All right, again, I'll get rid of the reclassification language. Page 15, removal of the employing agency. And then I'll ask anything else on page 15, paying particular attention to the differences with count 1 and count 2, the interrogatories on those. State, you're going to have to keep me honest on this one. I did the best I can, but
Yes,
thoughts as to employing agency and interrogatories.
Yes, sir. I mean, clearly the vehicle is not a firearm, so it doesn't, that language is not included in it. So, once again, I'm going to do my best. I think the court has been wise on saying vehicle versus firearm. And so I'll do my best to articulate to the jury that, you know, got to show 1, 2, 3, then the elements for attempted murder, first or second, then the law enforcement enhancer, 1, 2, 3, and then I'm going to go ahead and for the firearm, there's actually some more. So it's going to be, your verdict form is going to be sporty. That's probably what they're going to work off of, is take their verdict form, and I'm going to kind of work off of your verdict form and tell them how to fill it out, depending on their findings, if that makes sense.
What doesn't, what I want to make sure is based on the information charged, if I've gotten all of the right interrogatories, because there's actual possession, there's discharge causing bodily harm, there's a use of during the commission of the offense. The use of is the enhancement that takes this from a first degree to a life felony. The discharge is the discharge is obviously an enhancement. The discharge causing great bodily harm takes it from the 20 to 25. So I want to make sure I've got them all in there.
Yes, sir. I think that candidly, the use is is a little redundant with the, possession, discharge. If they find it, discharge causing, I'm going to, once again, looking at your verdict form, I guess you could use it without shooting it, but with the facts as they are, the state, I'm going to explain it based on the verdict form. Of course, I'm going to be arguing for the highest, and see it from that. I agree there could be a compromise. I'll do my best to keep it clean.
Let's put it this way. If they don't find, I get it. If they find attempted first or second degree murder of a law enforcement officer, that will foreclose a lot. But if they just find attempted first or second degree murder and they don't find a law enforcement officer, then we've got to look at, is this an F1? Is this an F2? Is this a life felony? And so that's where use will come in. And so I just want to make sure I haven't left out any applicable interrogatories.
No, sure. I understand what your point. I've got it. I'm comfortable where we are.
All right. And again, I'll be looking at it more this evening. And these aren't final until I give them to the jury. And frankly, there's some case law about even correcting during deliberation. And I hope not to get to that point.
Yes, sir.
All right. Anything else on page 15 and 16 all the way to just before theft?
No, sir. I'm good all the way to theft.
All right. Mr. Lawson.
No, sir.
All right. Now, as it relates to the theft, that's on page 16, count 3. Question on this is it's charged theft of a theft of a motor vehicle. The way the court has instructed it is basically as a simple theft, and then a special interrogatory whether it's a motor vehicle. So he's either going to get the misdemeanor theft or, well, he's going to get either not guilty, he's going to get the misdemeanor theft, or it would be the grand theft of the motor vehicle.
That's the only way I've charged it. I agree, Your Honor. The only lesser would be petty theft if they find it's not a motor vehicle.
All right.
And I agree with that there's nothing about the bypass steering wheel locking.
Right.
We can stricken that.
I've got that, the bypass. How about the court had noted and highlighted, but it seems like it would be applicable in this case, the proof of possession of a recently stolen property inference, the party's thoughts as to that inference. And that's the one before the steering column.
Oh, yes, sir.
Right. Mr. Lawson?
Yes, sir.
All right. And then as to value, do we need to give the, I think we still do need to give the value instruction, don't we?
Well, once again, I've set no value in the charging document, so I don't think I could argue that it's worth, I mean, it's going to go to the default M2.
Yeah, let's, hold on though.
I think I have of some value, but the specific, what setting the value and the fair market value doesn't really come.
Yeah, but the issue being is the court has to define property for them, which property means anything of value.
Right.
So, I mean, they could find it not to meet the legal definition of a motor vehicle, but even to get to the theft, they've got to find it was a taking of something of value. So the court's going to give the value instruction, but not any of the discussion of what the value is.
Okay.
They have to put some value on it to find him guilty of a theft. And obviously, if they're going to find grand theft, they have to find it legally to be a motor vehicle.
Okay.
As to the good faith defense, your position state?
There's been no evidence of any good faith at all.
All right, defense? And I'm sorry, I didn't catch that.
I ain't no, sir.
Okay. All right, I'm going to remove the good faith defense if the court does not find that it has been raised by the evidence. All right, as to anything else to count 3?
Yes.
Mr. Lawson?
No.
All right, count 4. This is the standard 2-element tampering with physical evidence. Anything from the state?
No, sir. Proper.
Defense?
No, sir.
All right, pages 19 or all of the rest of page of 19 is standard instruction. Anything from the parties?
For us, we've gotten to the weighing of the evidence, Your Honor.
Yeah, we'll get to that. I'm holding off
Right.
on that.
I'm before, no, sir, I'm not up until weighing of the evidence.
Mr. Lawson.
No, sir.
All right, as to weighing of the evidence, it would appear that 6 through 10 were not implicated. Do the parties concur?
I agree.
Mr. Lawson?
No, sir.
All right, the court will note we did have a law enforcement witness. We did have an expert witness. The court did not see any accomplices and informants nor child witnesses. Do the parties concur?
I do.
Yeah. All right, as to the court intends to give the pro se defendant instruction. I will not give the defendant testifying instruction, but I will, if you would like, Mr. Lawson, give the defendant not testifying instruction, and I will give one or both paragraphs. What is your preference, sir?
I don't understand.
All right, so there where it says defendant not testifying, it's on page 22, I believe.
On ours, it's bottom of 21, sir.
Bottom of 21, sorry. The defendant not testifying instruction. I will give that instruction at your request, and I will give one or both paragraphs. That is up to you. All right, well, the defendant having not expressing a preference, the court's going to give both instructions to protect the rights of the defendant.
Agreed.
The court will note the defendant's statements or statements purported to be by the defendant did come into evidence, so I intend to give the defendant's statements instruction. Is there any objection by the parties, and if so, what's the legal basis?
No, sir.
Mr. Lawson?
No, sir.
All right, then we'll go into the standard rules for deliberation in this case. Any discussion on that?
No, sir.
No, sir.
All right, and finally, standard cautionary instruction and the verdict instruction. The court obviously did give the multiple counts one information instruction. Anything as it relates to the cautionary instruction or verdict instruction?
No, sir.
Mr. Lawson?
No, sir.
All right, standard closing argument instruction, and then submitting the case to the jury. What I've noted down is the numbered paragraphs about what they're allowed to take back with them. I just say that some of these exhibits will be sent in the jury room with you when you begin to deliberate. If you wish to see any other admitted exhibits, please request that in writing. I'm not sending the gun back with them. I don't intend to send the open package with the glove back with them. Do we really need to send any of the stuff with biologicals that are in closed bags with them?
No, sir. And candidly, I knew I was going to comment during my closing on if they want to watch the video, which we can't set a computer. So I can address that in my closing and will on if they want to see something that we can bring them back in and let them play it or see it.
Yeah, I can't recall. Is there there's not a player back there, is there? There wasn't one. Okay, that's fine.
Like I say, but once again, that's going to be I think the most likely if they want to see or hear something. So what I'll do is, I specifically like the foam boards and the pictures I printed out so they can see those and take them with them. If they want to see anything else, they just need to let the bailiff know, and I'll kind of invite them to do that process.
Well, what I'll let them know is I'll let them know they're not going back there with the videos. If they want to, it won't be a matter of letting the bailiff know. It'll be, I want a written question signed by the foreperson. I'm going to do it by the book. That way, the record will be very clear that they're asking a question or requesting to view evidence. We'll bring them back in here in open court. We'll let them watch it. But where I don't want to get into is that, no, move it forward, move it back, move it forward.
Right.
We'll get it, we'll play it, and we'll be done with it. Anything else with the remainder of the instructions?
No, sir. Otherwise, the state's fine. Once again, I think a lot is going to be, I'm not trying to put pressure on the court, but the verdict form is going to be complicated. So I know because I tried to make it before you did it, and I didn't know how to do it. So when the court does that,
Did I not give you guys a copy of proposed verdict form? I did, didn't I?
I think you emailed it to me, but not in the recent draft. So that's where kind of the interrogatories, I want to make sure exactly, because candidly, I plan on going over the verdict form during my closing arguments. So I want to make sure I understand it before I try to teach it.
Then that's what we'll discuss tomorrow morning, because I've got it. I thought you guys had it. I thought I'd given that to you on Monday. To the extent, we'll finalize it tomorrow morning, but I mean, I think the verdict form's good to go. What I'm going to do is I'm not going to hold us around. What we'll do is we'll come back at 8:30 tomorrow morning. To the extent, what I'll do is, Mr. Campbell, if you want to approach, and you can take this copy. If you want to make copies, give one to the defendant if he doesn't have it, or you can give him this one subject to any security requirements. This one's got a staple in it. Subject to security, I've got one, and that way we can discuss it in the morning, get it finalized.
Yeah.
Go ahead, Mr. Lawson.
Is my wallet considered that evidence? Do y'all got my wallet in evidence? I mean, am I gonna be able to get that back?
Well, sir, your wallet wasn't entered into evidence, so that's not a matter yet pertinent to what we're dealing with. As far as return of property, that's a whole different issue, and we'll take that up at a separate time. But it's not in evidence, so it is not, at least. And by what I say by in evidence, it may be in an evidence locker. I'm not saying that. By in evidence, it is not in evidence in this case as a matter to be considered by the jury. Unless it was, well, let me see what, hold on.
Yes, sir, it's not.
No, because I was going to say, I know there were contents from, contents of jacket. I don't know what was in 15. That's states 15 is contents of jacket, FDLE number 14, items D3-1. I don't know if the wallet's in there or not, but it was some sort of, I remember the picture and I don't remember seeing a wallet, but I couldn't tell you for sure.
When DLE came and got my squad, they said that the state had the wallet.
Well, they may be, and that's, again, for purposes of what we're doing on this, that's neither here nor there. To the extent of a return of property, I'll let you deal with the appropriate authorities, and if need be, an appropriate motion or petition can be filed with either this court or the civil court if it's a writ of mandamus. So, and I'll allow, I can't advise you what process to use to do that, but I'll allow you to handle return of property in the due course. But I'm not dealing with that before we get a jury verdict in this case. All right. With that, then, thank you, everyone. I'll see you at 8:30 in the morning. The court is in recess.
Stop here, and then we'll continue tomorrow. Mentor Lawyer is going to take over. And if you want something else to watch, make sure to go to Deep Dive True Crime at 7:45 p.m. Eastern Time, where you are going to see unseen footage of Charles Adelson jury selection. This has never been posted to YouTube, so this is a YouTube exclusive, and you get to see what was actually happening during the trial they were just filming the floor, but you get to see the whole thing. So it is episode 1, so make sure you go check that out tonight, and let us know your thoughts on Dexter's trial and how he's doing representing himself. And yeah, we'll see you all tomorrow or tonight potentially. Okay. I hope all of you have a wonderful day today, and see you next time.